Yes.
Son, my lord, to the other side. For inclusion, my lord, this is regarding higher scale of pay, my lord, covered by the larger decision. Part 1 examination prior to joining. This is the we have been scheduled. 5 matters, my lord.
Upon notice,
For notice to the other side.
My lord, may I permit to mention one non-prosecution matter, my lord.
to be mentioned.
2019 matter.
What is the urgency? A monthly list. Monthly list July.
May your lordship leave to mention a matter, my lord, which is not your lordship list, my lord. Without mentioning upon notice, my lord, this is only for inclusion in the list, my lord. This is only
What is the urgency?
my lord, this matter is appearing, my lord, since 2019, my lord, the matter is not yet
I
been
know
taken up.
2019. What is the urgency? I have already included many matters. Kindly allow the
List, my lord.
mere enlistment of any matter will not suffice. Yeah, the court is to dispose of the matter. You consider
2019, due to change of determination.
why are you doing so since the last 6 years?
But only the matter is not appearing, my lord, due to change of determination, my lord. Your lordship would kindly consider, my lord. Please, my lord. Your lord would kindly consider.
Monthly list of July.
May I permit to mention, my lord, this is a issue of transfer. The issue, my lord, single teacher has been decided by this honorable court. So, my lord, the similar order may be passed, my lord. Transfer in respect of school teacher, the single teacher, it was rejected, my lord, after prolonged time, my lord, the honorable division bench has settled that the single teacher cannot be a ground for transfer. Though, my lord, the amendment has already been, my lord, made out on 3rd December, and based on that, my lord, honorable division bench has settled the issue. The district inspector of school is the authority to arrange the local arrangement and my lord, transfer. This issue has been settled. Plus, then my lord, the repetition may be discussed of in like.
The monthly list of July.
My lord,
Why is the notice to other side?
I have served a notice, my lord. I shall give. I shall give, my lord. Yeah, but,
No,
my lord,
give notice then mention.
yes, I have served, my lord. Yes, I am giving.
That today you will mention where it
Yes,
is.
today, my lord, I shall.
Oh, Mr. Panda, you have understood what court want to say.
Yes,
That today you will mention
my lord.
where is that notice.
My lord, I am giving, my lord. Only, my lord.
No,
10 minutes.
no.
Then, my lord, I shall permit, my lord, tomorrow.
A rule should be followed equally to all.
Let us praying for my lord, keep to mention my lord, 2 matters. Lord, I'm mentioning upon notice, my lord. The prayer, my lord, is for my lord, hearing of the application. Lord, for the moment, my lord, an order, my lord, directing them to my lord, consider my representation would suffice. Lord, so if this could appear is to be mentioned, my lord, tomorrow or Wednesday, my lord, this probably can be disposed of by just my lord, order, my lord, direction upon the respondents to consider my representation. Lord, if this could appear is to be mentioned. Will not press. I'm grateful to Lord.
I'm coming this
I'm
way.
grateful. Lord.
This is upon notice. Hearing under group 2 matters.
Land acquisition. Monthly list of July.
Monthly list of July.
Coming Audience side coming. Hey, Audience side কি এসছেন? হ্যাঁ? আচ্ছা ঠিক আছে। Okay, I am coming this side. Yes. What is the urgency? Remand the matter back. Monthly list of July. July the monthly list বিশাল হয়ে যাবে আমার। Monthly list of August. So monthly list of August, what can be done? There are other hearing benches. Why only one bench? You are coming only these benches. Everyone repentation of control. Where is the notice? So give notice, then come.
mention after this, I am mentioning item number 361 for upgradation. Urgency is this, the regularization of service, particular surveyor in the, by the, ministry in the year 2000. Thereafter, he prayed for his appointment for permanent appointment. The municipality considered the same and considered the peace prayer, and higher authority also directed that the post is a vacant post. But till date, no appointment for permanent appointment.
Regularization, you want regularization.
If it is
The municipality has accepted your contention. So why they have not regularized?
also higher authority
Monthly list of July.
Comment to mention, Lordship.
and upgradation.
Upgradation, wait for some time. Regularization can be given.
May mention for inclusion
With
on
the
pensionary
treaty,
benefit, Lordship. For
Huh?
pensionary benefit for inclusion. The petitioner stopped getting pensionary benefit from 2021, Lordship, and
Or under heading pension matter.
But maybe permit to mention on group 9 matter. This is a motion of 2021 minute.
Motion 2020, ma'am. A motion দেখুন
Should they be permitted to mention for inclusion in the list for hearing?
urgency. Eh? Urgency. What is the urgency?
But the matter is, everything is finished, my lord. The reply returned that everything.
You read the records and then come. What is the urgency? And then come on Thursday.
Small scale industry have been declared as an they will be declared me as an NP, and next and my company will be winding up, and next date is fixed before the NCLT on 7th of July. This week, any day. Otherwise,
So what is the proof of interference by the writ court at this stage?
they have without
Insolvency proceedings is going on. So no proceedings generally will lie.
find up. My
Why lie? So let the
If I find up my reputation will be instructed.
owned of your
My
company.
reputation will be instructed.
What is the scope? The company court is citizens of the matter. Now, what is the scope before the writ court to interfere at this stage?
Covered by the company code. They have taken wrongly. They have taken the course of wrong fora. That is my case. I'm not covered by that. I'm not covered by that. But I have often noticed I have mentioned also.
Okay, the upgrade করে দেবেন তো। Okay. You have not given notice to other side.
Yes, I have given notice on mail.
Okay.
On I have not
Urgent side কেউ আসেনি আছে। What is the no sleep, nothing.
Selection of petition, they are about to give the opposition, but they have not given. The difficulties because of the pendency of an appeal filed by the High Court Administration, I am protected by an entry order passed by Justice Government. Number the vacancy has not been filled. The difficulty is that I am not getting the venue. I am the intending candidate.
Okay, Thursday it will be taken up. Item number?
Last time.
এটা একটু কি আছে আপডেট করে দেবেন তো আইটেম নাম্বার 12 বলে দেবেন
another original side matter, my lords. My lord, the group 9 matter, my lords, affidavits are complete.
What is the urgency?
Content bank has issued a letter of credit, my lord. On the date of payment, my lord, LC dishonored, my lord, my payment has not been made.
ওকে অরিজিনাল সাইডের ম্যাটারে দিয়ে দেবেন
My lord, may I be permitted to mention one group 6 matter, my lord? It is the matter of disbursement of retirement benefits of the petitioner, my lord. In spite of specific representations and passing the order of the controlling authority, the National Textile Corporation did not disburse the benefits to the
ওকে
petitioner.
পেনশন ম্যাটারে হেডিং আন্ডার দ্য হেডিং পেনশন ম্যাটার দিয়ে দেবেন
Three matters for inclusion, my lord.
why
And, sorry, my lord.
why
My lord, inclusion for inclusion. My lord.
Inclusion, why? What is the urgency?
Transfer issue, my lord. Transfer issue.
We have joined the transfer post. You have joined to the post. Why you have been transferred?
No, my lord, my transfer has been pending. That's why I am mentioning. And one matter for upgradation, my lord. This is for higher scale of pay.
কি দেখছে দেখুন, you write down urgency and hand over. What is the urgency? Write down the urgency.
Okay, great.
In this matter, the petitioner is the guest. I am for the respondent college authority. In the corona period, an administrative order was passed by the principal that the poster of HON'BLE is the day section and chronic section, but it completely declined and therefore attended the classes. Filed the petition against the administrative order. Now the entire my education process is
Why? Due to pendency of the petition. Any stay order has been passed in an interim order. How your administration is suffering any obstruction in carrying out its activities?
we have filed the objection.
Okay, the court has not passed any interim order, has not restrained you. You run your administration according to your own way. Not now. Not now.
My lord, in this matter, the petitioners have challenged a reasoned order, my lord. In that reasoned order, my lord, the respondent authorities has not given us some benefits which are accruing from government orders and circulars. My lord, we are contractual part-time remunerated workers under the government of West Bengal. My lord, by that impugned reasoned order, the respondents have.
Okay, you will get.
This is a matter, my lord. Exchange of affidavits have been done, my lord.
Okay.
Matter is ready for hearing, my lord.
Okay, wait for some
Praying for
time.
inclusion, my lord.
Wait for some time. The monthly list to August.
My lord, August will be, my lord.
There is
Kindly.
Wait.
My lord,
My lord, may I have a lordship's kindly leave to mention one matter for inclusion, my lord. The urgency is that, my lord, the petitioner is not getting the money payment from the UTI mutual fund, my lord, because, my lord, the petitioner is a student of medical.
Mutual fund.
My lord, UTI mutual fund, my lord. My lord, the petitioner is a student of medical administration, my lord, and due to the finance.
Okay, wait for some
My
time.
lord, urgency is that
It is
there
not
a
so urgent
urgency,
that
my lord.
immediate intervention
My
is
lord, there is a
required.
division bench.
What is the urgency? Pendency is the urgency only. No.
My lord,
Many matters.
benefits,
No,
financial benefits are, my lord, being stopped, my lord.
no, rejected. Next.
my lord, due to some financial stringency, my lord, the
No,
petitioner
no, not now. Not
to
now.
continue his study, my lord.
I seek my humble permission to mention one original side matter for inclusion in the list under the heading hearing, my lord. I have been released from my service upon.
You have been?
I have been released from my service upon applying for voluntary retirement scheme in the year 2024. Thereafter, the institute is not paying my VRS. They are denying the scheme now.
They have not accepted your
Not
prayer for
disbursing my
voluntary retirement.
Yes, voluntary. They are not now disbursing. They are denying.
You are doing your job.
No. I was released upon applying for VRS, my lord, due to health issue.
Monthly list of July.
My lord,
Yeah, call the list.
my lord, this matter was mentioned by before your lordship, my lord. Your lordship was allowed this mentioning, but my lord, it is not. It has not been listed, my lord. Before
Monthly list of August.
my lord,
Monthly
July,
list
my
of
lord, my lord, July. But it is there are some.
Many matters. Yeah, next, call the list. এই কোন আরো বেঞ্চ আছে তো না হিয়ারিং নিচ্ছে?
Is the only available regular bench for hearing. This is the
No, there are other bench also. এই আছে না?
irrespective of classification, and here your lord.
জাস্টিস পার্থ সেন আছে না তন্ময় বাবু? পার্থ সেন আছে আরো আছেন।
Notice Shane, my lord, Justice Shane has also determination of regular land matters thereafter. But your lordship is already taking up regular hearing matters. This is
Oh.
the advantage we have before you.
Oh. Okay, yeah, what is the matter about?
My lord, item 1 to 18, my lord.
Hmm.
Your lordship member, your lordship previously released similar matters because a similar matter is being heard by a coordinated bench that is heard in part. We have completed our argument. The petitioners, it is the Advocate General who we will reply, my lord. The matters relates to, my lord, we are contractual whole-time teacher in colleges. We are paying for equal pay for equal work. The matter is being heard in part by Justice Sengupta, my lord,
আচ্ছা,
and we have completed our argument.
এটা কি আইটেম নাম্বার 1? হ্যাঁ, এটা তো রিলিজ হয়ে গেছে। ও ও, ওকে ওকে, এই আসুন, এই বাবু। Oh,
Your Lordship, the matter is not appearing at our instance. Your Lordship may remember Mr. Bandopadhyay was making submissions about the passport production, and Your Lordship had directed the matter to appear on 8th.
এই তো 9
Yes, my lord. Yes, my lord. I appear for the petitioners. My lord, at the very beginning, I tender unconditional apology for appearing virtually. My lord, due to a medical compulsion. My lord, this matter came up on 23rd, 25th of
8 জুলাই 8 জুলাই
8 July. 8 July. My lord.
হ্যাঁ, ও এই একটা এম করে দেবে তো, একটা পিএম লিখে ফেলেছেন দেখুন সুমন বাবু, এম। হ্যাঁ, ওকে 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 ওকে, ফর কারেকশন ইট হ্যাজ কাম।
Very good.
হ্যাঁ,
Advocate on record, Bikram Banerjee.
ইয়েস 2022 22 দেখি তো, 22 submission। হ্যাঁ হ্যাঁ,
My also 3 matters was along this matter. My matter is appearing under the heading Part 1. Item number 90, 91, 92. Along with this matter, my lord, it was appeared on last Monday on 23rd.
সো এটা পাঠাতে দিয়ে দিন, পাঠার ম্যাটার নিন। নেক্সট, আমি যা খুশি যখন খুশি, আমি তন্ময়বাবু একটু বিকেলবেলা লিস্টটা নিয়ে দেখা করবে, সবাই করে।
All these matters appeared as grievance.
ওকে, রংলি এরোনিয়াসলি অ্যাপিয়ার। হ্যাঁ হ্যাঁ, 23 দেখি 23। ডিডি করে দিন, নন অ্যাপিয়ার অন বিহাফ অফ দ্য পিটিশনার nor has any
Lord, I beg to appear for the
yes, correspondent.
My lord, I am for the petitioner. My senior is at court number 1. I am seeking for a short passover.
No, no, ইয়ে করে দিন। আমি আর কি go out of list করে দিই আর কি।
My lord, in that
My-
case, one indulgence that affidavits may be directed for.
হ্যাঁ,
Affidavits may be directed for, my lord.
ও
My lord, according to the last direction, supplementary has been filed and it has been also served.
আন্ডার দ্য ইয়ে, আচ্ছা আপনি করুন। আচ্ছা, having heard the, so I'm giving direct
had taken up an allotment in the warehouse for the purpose of storage. Now it was for a tenure of 3 years. Within 3 months, on a 2 days notice, they vacated the warehouse. Now we have deducted the amount of the total tenure, or even if it is vacated, my lord, there has to be a notice period. That notice period was not served. Under such circumstances, my lord, we have withheld the security deposit.
Oh,
Affidavits may be called, my lord.
My lord, kindly consider one thing. My affidavit of service, I have annexed one document. Supplementary affidavit, my lord.
I am calling for affidavit. Let the matter heard out under after exchange of affidavit.
One thing, my lord. In supplementary affidavit, page number 5, my lord.
Very conspicuous document, my lord.
Where is the supplementary affidavit?
Last occasion, there is an order for file and supplementary affidavit.
Yes.
Page number 5, my lord. We have already paid the dues to the authority, and subsequently they did not release our security deposit amount.
No, they have given vacant possession of your warehouse.
Yes, I already delivered them.
This particular document is issued by an officer who has superannuated long time back. This document also does show.
You are the owner of the warehouse. So
I have take a rented go down from them.
Oh, United Tradecom Private Limited is the owner. Oh,
no.
So
My lord, United Tradecom, they had secured a reservation in our warehouse. The warehouse is owned by us.
Yes. Oh.
Basically, it is as if it was rented out.
My lord, kindly
Okay. Allow the court to understand. Warehouse is Union of India.
No.
Central Warehousing Corporation.
Central Warehousing Corporation. They reserve a place of that warehouse.
Right.
Okay.
May I submit my prayer?
Thereafter, dispute cropped up.
Because
now they have hand over the vacant possession of that place in your favor.
Yes.
Now, at the time of allotting place in their favor, they kept certain amount as security deposit.
My lord.
Now they are claiming that you will refund their security deposit.
That is their claim.
So what is the cause of withholding the security deposit?
I tell your lordship, there was a particular tenure for which the reservation was made. Now, your lordship knows that in case of warehouses, my lord, if there is a tenure which is secured and that tenure is not frustrated, in that case, there is a huge loss on the part of the government, because that cannot be allotted to any other person, because the tenure has to frustrate. Now, we would have understood if they would have given a sufficient time frame for vacating. Your lordship sees within a span of 2 days, they gave a notice, within 2 days they vacated. So, my lord, there is a revenue loss. There is a revenue loss on the part of the government. Even assuming that if it is a general tenancy, in that case also 15 days notice is mandatory. They have not done so. They just say that our business is not working. They have not showed any documents showing that they were allegedly working with the Amazon.com, which is the platform for online shopping. Now, they say that our business is not working, we are vacating. There is no reasoning, nothing as such. They are well aware of the fact that when it comes to government warehouse, they have to provide a notice, or they have to give a notice at least 15 days prior. Though here the clause is 1 month, but since there was no formal agreement as such, at least 15 days. So, my lord, we have suffered damages. The quantification of the damages, my lord, I need to place that on affidavit. That is why I was seeking for directions.
We come to my application. I have annexed my representation which I submit before them. I have clearly stated that they did not make any agreement for which I have faced travel to run my business. Kindly come to page 21 my application.
Okay, that should be.
Then kindly one piece of paper, my lord. Kindly come to supplementary affidavit, page number 5, my lord. One piece of paper, kindly.
When two parties are not at idem regarding their claim,
they are.
So there is a dispute. Dispute is to be resolved.
Yes, my lord.
You are saying that that security deposit, the amount which was deposited as security
Yes.
should be refunded.
Yes, yes.
He says that due to your conduct, he has suffered loss of revenue.
My lord, they have given condition.
So there is a claim, rival claim.
My lord, kindly come once for page 5, my lord. They have directed me to refund the security deposit against the withdrawal of court case.
Which page?
If I did not file the application before your before the honorable court, they will not refund the security deposit amount. Kindly come to page 5 of my supplementary
Lordship
affidavit.
reads the content of the letter.
First, my lord, kindly subject. Then, my lord, content.
Content will not, the subject will not supersede the content. The content is the intention of the party.
This is their reply after filing this application before your honorable court. They are only.
Now, my lord sees.
No, they have, yeah.
The offer of settlement was in 2021. Till date, we have not received any offer from
You are requested to submit a terms of settlement in the agreement form.
2021. What they are saying?
In 2021, there was an offer of settlement. Till date, no offer, no nothing, no piece of paper we have received whereby they show positively that we want to settle the
Because my lord,
5 years have lapsed.
Before the honorable
5 years have lapsed, my lord. They are the petitioner. The carriage of proceeding is on them. The carriage of proceeding is on them.
What High Court will do? Force them to accept the terms of your settlement as you want.
My lord, they have asked me to withdraw.
You settle the matter, sit with them, settle the matter.
But they are not refunding my amount. What will my settlement?
Awesome.
They are asking.
Having heard the present Next.
My lord, affidavit of service may be kept with record, my lord.
আচ্ছা, এফিডেভিট সার্ভিসটা দিয়ে নিন। It is part of the matter wrongly appeared under the heading to be mentioned.
Whether any appeal has been referred against the Supreme Court goes when Learned Senior Friend also is present, my lord other side is present, but when Supreme Court goes, that order has been complied.
হ্যাঁ,
No appeal has been prepared, order has been complied. This is the compliance report of the Supreme Court.
so tomorrow এটা করে নিন, tomorrow along with other three matters. Along with other three matters, হ্যাঁ ঠিক আছে, এটা আপনি ইয়ে করে দিন, ফোন অর্ডারসে রেখে দিন। Oh, so you have to inform the other side. Oh, no. Their presence on earlier occasion will not suffice. You serve them. If they remain present, then your matter will be taken up for hearing, otherwise not. You ensure their presence. Eh? Yes, Mr. Janas. Okay, ওইটা দেবেন, ফর অর্ডারসে দিয়ে দেবেন। Yes, next.
Item number 25.
Item 25, my lord, I am for the petitioner.
Yes.
This is my
Who is your other side?
this is my affidavit of service.
Wednesday. Wednesday. Wednesday, give notice. Yes, what's the matter about?
This is my affidavit, and I wish to file a supplementary affidavit, my lord. My lord, this is the main crux of the matter is that petitioner wrongly, my lord, transferred 22 lakhs rupees to respondent number 7 instead of respondent number 6. My lord, why that mistake happened, my lord? Because the kindly see the respondent number 6 name is, my lord,
Respondent number 6 is Sudhir
Kumar Kanti Gohel, carrying on its business under the name and style of Messrs MS Trading. And my lord, respondent number 7 is Sachin Sharma, carrying on business under the name and style of Messrs Trading Company. So this is the Messrs, one is respondent number 6 is Messrs Trading, and respondent number 7 is Messrs Trading Company. This is the only difference. And as such, my lord, the petitioner, my lord, herein wrongly transferred this 22 lakhs.
You erroneously transferred in favor of respondent number 6.
Seven instead of respondent number 6. Immediately, my lord, I informed my banker as well as the respondent number 7's banker, and my lord, series of communication exchanged by and between the parties. Even my lord, complaint was raised on behalf of the respondent on 24th December. My lord, kindly come to page 24 of the writ petition. Series of communication, I will not trouble with your lordship.
No, how you have a supplementary affidavit, how you have served upon the respondent number 7.
Respondent number, my lord, I have filed affidavit of service, my lord. Kindly, my lord, I have filed affidavit of service.
Where is the affidavit of service?
Given affidavit of service. By speed post.
In which bank it was credited?
Credited, my lord, respondent number 7's bank. This is, my lord, DBS bank. DBS, my lord, respondent number 4. He is also a party. Respondent number 4. Account number, page 6, paragraph 12, account number was also given.
Now, how you are seeking intervention of the REIT code?
My lord, kindly see page 24.
Now you are seeking direction upon the bank, that is ICICI Bank.
Well,
It's
after
a
that,
private bank one.
well, after that, what happened? Well, kindly come to page 24 once. P6, page 24. My lord, I have written a letter to Banking Ombudsman Department. Page 24, my lord, kindly come.
That they have not done any.
They have not done anything on the on contrary, after filing this writ petition, what they have done, my lord. This is my in the supplementary affidavit, my lord, kindly see. They have just closed this thing.
Close
the dispute mechanism. Kindly see their language, even page this supplementary affidavit in P9. This is the page 4 of the supplementary affidavit. May I read this? Please refer to BO complaint number so and so. In this respect, we advise that your complaint has been examined by BO based on documents submitted by you and your bank. Complainant himself had transferred the amount to wrong beneficiary, and for sending fund to wrong beneficiary, the bank could not be held responsible. In this regard, no deficiency in the service can be established on the bank. Secondly, on receipt of the request, the bank had taken all the necessary steps to refund the fund. This has been admitted. Without obtaining a debit mandate, it is not possible for a bank to debit any amount from an account. Moreover, bank have placed hold on that amount and have sent letter to the beneficiary, which was returned undelivered due to shifting of office. They have admitted, my lord, they have taken steps, but they could not do anything. The bank have conducted field verification by its official to confirm the same. Thereafter, the case does not.
Moreover, bank has placed hold on that amount.
Yes.
And have sent letter to the beneficiary, which was returned undelivered due to shifting of office.
Yes.
The bank have conducted field verification by its official to confirm the same.
Yes.
Therefore, the case does not reveal deficiency in the service rendered by the bank.
And the case is accordingly closed.
Yeah, so what wrong the ombudsman has done?
On the one hand, my lord, they are admitting that there is a deficiency, and as such, they, my lord, they are trying
there is no deficiency.
No. On one hand, they are admitting there is wrong transmission. As such, they are willing to refund the amount. They are willing to refund the amount. But the problem is that since, my lord, they have changed the office, that is why they could not do so. They are admitting that they want to refund the amount to the petitioner, that is to me, my client. But, my lord, what difficulty they are facing is that change of registered office, and that is why, my lord, they could not dance. That is why, my lord, I am humbly paying direction upon them to refund my amount. This is
The
my
payment was
hard-earned
made by
amount.
check. Payment was made by check.
Payment was by bank transfer, my lord. My lord,
bank transfer.
My lord, this is 22 lakhs.
NFT or RTGS, anything like that.
My lord, 22 lakhs, yes. Yes, my lord, page 18, my lord, kindly see transaction details.
So you file suit, what REIT court will do, what ombudsman will do.
Because the deficiency on the part of this is clear deficiency.
What is the deficiency?
Deficiency in the sense, my lord, they are willing to refund the amount. It is not their case also that we are not eligible to refund. They are also admitting that we are entitled to get refund. But since, my lord, there is a change of registered office, that is why they are. I am humbly paying a direction upon the respondents to refund my amount. This is my hard-earned money, my lord.
How?
Kindly made a direction upon them to refund my amount in accordance with law. What is the procedure is? Otherwise, the bank will not do.
Private bank one.
Look, private bank one. In case, my lord, violation of fundamental rights.
You just a private bank one. You just say the private bank is amenable to jurisdiction whether there is a question. However, you sought involvement of the ombudsman and only to invoke the jurisdiction. Ombudsman find there is no deficiency of the bank. If any amount is credited in the account of any customer of any bank, okay, what is the deficiency of the service of the bank concerned?
My lord, I could have
said. And how, without any order, either order will come from the customer that you debit that amount in his account. A direction comes. When you are sending a money, that means a direction is going to the bank that you send such and such amount of money from my account to his account.
My lord,
Based on this direction, only the money is being transferred.
my lord, I
Okay.
could have understood.
So unless there is a specific direction upon the bank, coming either physically or through electronically, the bank cannot transfer.
My lord, I am.
So what is the deficiency of service of the bank?
My lord, may I answer this? My
You
lord,
file suit, what can be done?
my lord, what happened, my lord?
An injunct
My lord, 22
the
lakh,
bank.
22 lakh, my lord, I direct the respondent, this bank, my bank, to transfer to respondent number 7. What wrong they have committed, my lord? They have wrongly, my lord, transferred this amount to respondent number 7 instead of respondent number 6. This is the deficiency on their part. And my lord, secondly, this thing 22 lakh.
You could not understand what I want to say.
My lord, I understand. I understand
If
what
the
sorry.
ombudsman, who is the state to some extent, if there is a inaction or overaction, anything like that, a writ court can enforce to discharge his statutory duty. But the private bank is not amenable to the jurisdiction.
The private bank is
It is totally private business.
my lord, I will, my lord,
Okay,
show
private
judgments
business.
when there is a violation of fundamental rights. My lord, private bank can even. My lord, I will hand over those judgments.
Many other another judgment also.
My lord, it is
So
not.
I am seeking affidavit from the
Only my lord can seek evidence.
actually
Only
you
my lord secure my amount. That is my only prayer. My lord.
you
My lord,
want
there
a
is that
direction from a writ court upon a private bank to release a amount in your favor. You want a direction from a writ court.
my lord, kindly direct them to file a report then. Kindly direct them to file a report that whether this has been done or not. That much that then they will come and they will tell that what the real scenario is.
What bank will do?
Well, the bank has
Whether there was any due or not, whether there was any transaction or not.
my lord, the bank is the culprit because the bank has wrongly transferred the amount to respondent number 7 instead of respondent number 6. The bank has admitted that. The bank
has transferred.
Bank has transferred. I have directed that is my case. That is my case, my lord.
What was your direction?
My direction was
upon the bank.
Respondent number 7 to transfer the amount to respondent number 7. Instead of that, what the blunder they have done, they have transferred since that Messrs Trading Company and Messrs Trading. They have mistakenly transferred it to respondent number 6. That is my case. And now at present they are saying that
intervention.
Although
intervention by a writ court will be
satisfied, my lord, on that point.
Intervention by writ court will be a precedent. Then everyone will come regarding every transaction made by a private bank. It is totally there is no public law element.
Lord, I will
no public. It is purely a matter in between a private bank and his customers.
My lord, I will satisfy you on that point.
Okay,
my lord.
One transaction between a private bank and its customers. You say that what is the private law, public law element?
My lord, I will
why writ court will interfere?
I will satisfy you on that point that whether the writ court has. My lord, I am submitting that writ court has jurisdiction even in the case of private bank when there is a case of violation of fundamental rights. I will satisfy you, my lord, on that point.
Every violation is the violation of fundamental rights.
Case of
every violation is the fundamental right. For the judgment.
But I will.
Judgment. No, never. So private bank, you will get a status of a public bank. You so.
My lord, direct. If my lord directs them to file a report, my lord, then that will suffice. That will suffice my purpose. My lord directs them to file a report. Yes, my lord. This my lord, by 22 lakhs is struck, my lord. Kindly appreciate.
Amount is not.
Is not, my lord. Kindly appreciate.
Amount is you are before that court. Which order shall be passed today? That will be precedent tomorrow. Tomorrow you will come with that order. That it will create a precedent. No. You appear, Mr. Chatterjee, just you appear on behalf of Punjab National Bank. Oh, Do you know who appeared on behalf of ICICI Bank? In motor vehicles matter, yeah, there are some advocates who appear. That is insurance company, not bank, insurance company. Private matter one. Well, okay, I am giving you 1 week time. Either you can.
Mala, kindly seek a report from them within 1 week. They will file the report.
I am not satisfied as yet.
Mala, kindly
That should be intervened. I am not
kindly,
satisfied.
kindly direct them to file a report. Mala, within that, Mala,
I am not satisfied at all as to whether it would be fit case to interfere by the writ court or not.
Then Mala, kindly direct me to serve respondent number 7. I will serve once again if they appear, my lord. Since they are not appearing, my lord, kindly direct me to serve upon them. I will serve upon them. So whether they will.
If I am giving you time, you bring that judgment.
I will bring the judgment.
Regarding private transaction in between a private bank, again, I am formulating law for you, legal law point. In respect of a transaction in between a private bank and its customer, writ court shall have jurisdiction to interfere in the same.
My lord, I will do.
Okay, private transaction, no. The matter precedent on the case-to-case basis. A judgment is to be applied whether it can be applied in the fact and circumstances of this case. Okay, according to the perception, it may be, I can amend myself. If you can show any judgment and authority that in respect of a transaction in between a private bank and its customer, writ court has the jurisdiction to interfere.
Well, in the meantime,
Next
may I serve once again to the respondents? Because they are not.
Serve or anything. You may serve. No direction. Not a single word shall be used unless you can satisfy the court. Okay. Next.
26. This letter I am nothing for the people.
কত চেঁচাতে হয় গলা থার্ড
made an application for his future certificate, but as his father
caste certificate has not been issued and why petitioner has not been sent before to the selection committee, it's not good. Caste certificate SDO.
But Lordship, according
SDO Gangarampur. Who is appearing for the state. No, it was the notice given earlier in the year 2022.
giving
You give a press notice. So not this week it is running in the list at any point of time. So I am not passing any order. Okay. Not this week.
But 27, my lord, I am for the petition, my lord. Pursuant to a work order issued by the respondent authorities for the construction of a the auditorium and the children's park in Mohishadal, my I was entrusted with the work for raising such project work, my lord. Due to the several external impediments, petitioners suffered a lot, at the time of raising such construction, on the ground, there was the adverse geographical condition, there was a pond, and there was all the time there was a water. Due to that, we have suffered a lot, thereafter, the respondent authorities had changed the drawing of the project, that's why also I have suffered a lot, since we have already raised our the foundation work that was also to be removed, thereafter ultimately the petitioner substantial work was done by petitioner. Thereafter, petitioner made an application for refund of his the earnest money as well as the earnest money as well as.
So you could not complete the work.
No.
project.
Could not
You
be
could
complete.
not complete.
Complete.
Oh,
And as
okay.
well as the security deposit, my lord.
Okay,
That is pending.
you are removed, and a new contractor or
That I do not know, my
new
lord.
person was inducted. Miss Pajamoli, now you are reading. Oh, so much of brief you are holding that you are not getting time.
Unless
When the
and security
matter is
deposit,
being
my lord.
taken up, then you are getting yourself prepared.
No, Lordship, I was trying to
But
find
page
out
40
only
and
one
42.
thing, if the general conditions include
So
the,
through midway, he was removed.
yes, termination has been done.
Another person was inducted, and he has completed the project.
Yes.
According to
Yes.
yes.
Yes, Lordship.
Now he wants to get
His
Unless
security
money as well as
deposit.
security deposit.
earnest money and security deposit.
I just wanted to find out if there is any clause for arbitration in the
No,
general.
no, no. There is no clause,
I
my lord.
just-
I have checked up, my lord.
Oh,
My lord, page. Yes, sir, my lord. I have checked up. There is.
it is also the matter to be looked into.
No.
Page কতটা আছে?
Nowadays,
No. Tender notice টা দেওয়া আছে। আর করেন না। My lord, page 46, my lord. Kindly see, my lord. The tender notice, my lord, which indicates, my lord, clause 15, there shall be no provision of.
no agreement was entered into by and between you and the authority.
No, kindly see, my lord, clause 15 of page 46, my lord. There shall be no provision of arbitration. Clause 15. Clause 15. Clause 15.
বুঝতে পেরেছি।
No provision. You have just annexed page 5 of 35.
Yes, my lord.
No, my lord. The notice invited tender comprising of 35 pages.
My lord, kindly see, my lord, the relevant page clause 40.
If
page 40.
court would not look into, you could have got the order. Yes, no arbitration. So I am giving you 5 supplementary affidavit. Okay.
Annexing the entire document.
Rest document, yes.
Or my lord,
Rather you withdraw with liberty to file afresh.
or my understanding, my lord, may take instruction, my lord.
Why take instruction?
Because Lordship, there is a forfeiture clause, which is.
No instruction letter. First court will understand.
I have the instruction, Lordship.
And document in complete form should be placed before the court. Notice invited tender contains 35 pages. You have annexed only 5 pages.
But
so whether I shall take it otherwise.
No. It is of
that you have willfully suppressed the rest page.
It is of 2022, my lord.
You have
Transfer.
willfully, you have not annexed the rest page. Why?
Transfer brief, my lord.
You are seeking an order,
Since there is
seeking a justice from the court. You will only place 5 pages.
But there.
But the documents content 35 pages.
Let my understand take instruction whether.
I have the instruction, Lordship, the security deposit and the earnest money has been forfeited. There must have been a forfeiture clause. So that is not here. I'll come back with that if Lordship, if they may provide the document or I have to come back with the document. Because that clause is sufficient. I have the memo showing that it has been forfeited.
You withdraw and file afresh. Is a technical reason on the self-claim problem of action. Annex all the document.
But since no decision has been taken, my lord, they have now saying, well, it has been forfeited.
They are stated that they are forfeited.
But let them submit the report, my lord, so that I can challenge that decision. That decision I can challenge, my lord.
No. Yeah, no. Yes.
Since, my lord, we have sought for, my lord, the security deposit, no decision has been taken.
The person who has come with incomplete document, his pair will not be entertained.
Or my lord, I shall
He
come
was
up.
taking advantage of this.
My lord, I shall come up with
Okay,
a
he
supplementary.
didn't want to place entire matter before the court.
My lord, I shall come up with a
Why I shall not cause?
Right.
Impose cause.
No, my lord, I shall come up with a supplementary.
Huh?
I shall file a supplementary.
Always no kindness. Forget this thing.
No, my lord, I shall come with.
Come with clean hand before the court.
But
what is the reason that you have not annexed the rest?
That is not,
30
no, my
pages?
lord, it is a of 2022 the transfer brief, my lord.
So you don't want to show the court the
No, my lord.
forfeiture clause,
No, my
and you did not want whether there is arbitration clause.
There is no arbitration clause, my lord. It is for page
Arbitration clause is not there, Lordship.
page 46. It is just there.
Clause is
It
there
is stated,
in
my
the
lord.
general terms of contract, conditions for contract, clause number 2, clause number 2, pardon me, Lordship, clause number 3A.
There is a forfeiture clause, and you have forfeited.
It has been forfeited in 2018. He has filed the writ in 2022.
But that decision was never communicated, ma.
There is a
But let the decision be communicated so that I can challenge it, ma.
So decision.
I think the decision, I'll just go through it because just give me 1 second, Lordship. If it has been communicated.
It was communicated. He has suppressed, as he has suppressed the rest page of the notice inviting tender. Belief is such a thing, fragile. Once broken down, it is hard to get back.
Yes, ma'am.
Okay.
Today I'm a bit handicapped, Lordship, in regard to the communication, Lordship. I am not finding it in my.
Okay, I am giving you time to take instruction. If the order by which you forfeited their security deposit not communicated as yet, you communicate the same. Okay, in the meantime.
Yes.
Okay. Are the learned advocate appealing for the petitioner? Stop, Mr. Pajamo.
Mentioned that rescind the contracts as aforesaid upon with determination your security deposit stands absolutely forfeited to the government.
Now you pay the compensation.
Yes, my lord. But
since you have forced the authority to complete the rest portion of the work by engaging another person.
But by 15, my lord, we have intimated the authorities, my lord, that we are unable to execute the work, my lord, due to, my lord, certain external, my lord, impediments, my lord. And we have
now Pacific Relief Act has amended, everything has been changed.
Separate.
Those days forget that since I have got one tender, I shall do it according to my own way. 2 years job, I shall do it for 5 years. Forget about that.
There were
You
certain,
are
my lord,
truly dealing with the public money.
there were certain external impediments, my lord.
So you withdraw the writ petition
Or by
and
may I,
attend them.
may I get a copy of my lord, the order, my lord, so that I can challenge it, my lord.
Copy of the order is with you.
Yes.
To hand over. Stop. The present writ petition was preferred. Challenge is not barred by any law. It's not barred by any law.
For the petitioner, my lord.
We have the state respondent, my lord.
But the West Bengal Incentive Scheme 2013, my lord, was introduced for MSMEs, my lord. My lord, in the manufacturing sector, my lord. My lord, for
Subsidy the petitioner.
my lord,
As to why, once the inquiry report was approved,
was designed, my lord, to encourage, my lord, the establishment and growth of new, my lord, the industrial units in West Bengal, my lord. My lord, under that scheme, my lord, the respondent authorities, my lord, granted approval for production for establishing production ice cream production unit in favor of the petitioner, my lord, page 15, my lord. My lord, thereafter, my lord, the bank we have taken the bank loan, my lord, page 16, and also we have purchased the machineries, my lord. And thereafter, my lord, petitioner has made an application for page 20, my lord, for capital incentive subsidy in terms of that West Bengal my lord, the incentive scheme 2013, my lord. Thereafter, my lord, page 21 is the inquiry was held, my lord, and the officer, my lord, concerned officer, my lord, has recommended for subsidy, my lord, page 25, my lord. Thereafter, my lord, the respondent authorities had purportedly without any hearing, my lord, has rejected my claim, my lord, page 36, on the ground that the bills, voucher, money received of plant machineries as submitted by the petitioner are fabricated. The authority who had conducted the inquiry has upon verification of all the documents has recommended that for subsidy in favor of the petitioner. But the General Manager District Industries Center Birbhum, page 36, has rejected the claim. Thereafter, petitioner made an application for reconsideration of his claim, page 37, but that has not been the considered till date.
My lord, he submitted two sets of documents, fabricated documents. At the time of applications, he said some documents, and when we made some clarifications before the petitioners, he said some documents that is a fabricated one. Lordship, may I place two documents?
No, at the time of verification or examination,
Inspection, my lord.
also he submitted fabricated documents.
Lordship, at the time of application for taking
When you were satisfied that he is entitled to get subsidy,
at the time of application for incentive, my lord, he submitted some documents, and after my lord sent some clarification to the petitioners, and he supplied those documents. Those documents are not tallied, my lord. That is a fabricated one. Lordship, may I come with the documents, my lord? If my lord produces it is, my lord. The Joint Commissioner of Commercial Taxes, my lord, sent a letter to the first one, 6/6/2017. General Manager District Industry Center Birbhum wrote a letter to the Joint Commissioner of Commercial Taxes, supply of the machineries by Uptake Machineries and Constructions. We find from the office record in connection with the West Bengal Incentive Scheme 2013 that Uptake Machineries Constructions such and such under registration from Government of West Bengal such and such has supplied machineries under invoice number such and such, challans, my lord, Manali Cool Food Presses such and such. Besides the NHC, we are requested to kindly to inform the undersigned whether the above machinery supplies has been legally authorized to supply machineries, whether it is valid or not. On the next page, my lord, next one, my lord. The reply, the Joint Commissioner of Commercial Taxes. With reference to the above, on the subject, I would like to inform you that the two invoices being numbers such and such Uptake Machineries Construction to the Manali Cool Foods Presses appears to be invalid, my lord. And as such, as the dealer has not shown the sale in his returns filed in the relevant return period. As to the questions on having legal authority of the dealers to supply of the machinery, it can be said that the being registered dealers with RC
coverage of the retailer and worker construction uptake machineries construction can supply the machineries and others. This is for your information.
But all the documents which
super
my learned friend is relying upon, my lord, is of June 2017, my lord. Although my lord, the impugned order was passed, my lord, March 2017, my lord. Those documents are afterthought, my lord.
No, there is no afterthought. There's the inquiries, my lord.
But
And
in March
my lord,
2017,
that
they have
is
rejected.
submission, my
Subsequently,
lord,
they are
at
relying
the
upon
time
documents
at
of
the
June
time
2017.
application, he submitted some documents and the clarification, my lord. When we made some clarification, he sent some documents. That is a separate one, and that is not matching, my lord. We wrote a letter to the commercial taxes, and he replied those documents, my
So
lord.
I'm inviting affidavit. What can be done?
Or my lord, let
There's a fabricated one, my
a
lord.
decision be taken after giving an opportunity of hearing. My
No,
lord.
there is
Let
no
on the
question
basis of my application for
They have
request.
already taken
He has
decision.
already rejected, my lord. We already rejected.
They have already taken decision that you have lost this claim of for subsidy by submitting fabricated documents.
And the authority, my lord, upon verification, my lord, recommended my case, and my learned friend, the documents which are relying upon of June 2017, although my lord, the rejection was made in March 2017, my lord. But those documents are subsequent documents, my lord. Subsequent.
So your remedy lies on a determination that no, the documents which are submitted by you are authenticate, and hence you're bound to act on this document and release the subsidy.
And my lord, at the time,
Then only you will get your result, what you want.
Then my lord, they file
Okay.
affidavit or report, my lord, or report, my lord.
and at the
Now you want determination, this determination by a writ court.
and my lord, at the time of inspection,
My lord, kindly see
Whether
it was
document
closed.
is fabricated or not. Now question is whether the documents submitted by you are fabricated or
My
not.
lord, kindly see their conduct, my lord.
Now this determination is to be done by the court.
They have, my lord, initially recommended my case, my lord, upon verification, my lord.
after clarification,
Thereafter, my lord, all on a sudden, without any
And here
hearing, my lord.
many stakeholders are involved. Ice cream factory means you have purchased a machinery from another factory who is private. Okay, he is not party. He is not bound to produce. So your license, whether you have a license to sell out a machinery, or such and such machinery or not.
my lord, is the fact that at the time of
date
inspection,
by-
my lord,
Hard
it was
before
so.
the writ court to decide this issue.
At the time
My
of
lord, it has to be,
inspection, my
but since, my lord, the action is arbitrary, my lord. Kindly cease, my lord.
Now, whether his bill issued by you are proper or not, but authenticate or not.
But their report is saying something, my lord. Their report is saying, my lord, they have recommended my case, my lord.
I am inviting
Or report, my lord, instead of
why reports? This shortcut method has been initiated. Shortcut method cannot be used always. When a simple answer from the authority will give inputs to dispose of the matter, then report can be called for.
Grateful, man.
Yes. The petitioner
29, I appear for the writ petition, my lord. My learned friend is there.
But 2 and 3.
My lord, may I just, my lord, before your lordship looks at the papers, may I just trouble your lordship with the facts once, my lord. There are two issues involved. First is I have taken a loan with the Contai Cooperative Bank, absolutely comes within the fold of Article 12 of the Constitution state. I have not been able to repay the loan in terms, there are disputes. They take refuge to the SARFACI Act. 13.2 notice issued, 13.4 notice issued. Those line, lordship understands what SARFACI proceedings. Now, I am not challenging any of that. That's not the subject matter of the writ application. I approach them, say that you get into an OTS proposal with me. There's counter allegations, I come before this honorable court. There is an order passed by Justice Devanshu Boshak in an earlier round of litigation where Justice Boshak says that you make an application for settlement, they will consider and dispose of my application. Then that order is there. Accordingly, I make applications. Then again, allegations, counter allegations. I come back by way of the second round of litigation, another writ petition, where Her Ladyship, the Honorable Justice Moushumi Bhattacharjee, passes an order and says that you have not considered also the OTS proposal. The court, the writ court, I was hearing your lordship in a previous matter, lordship is absolutely right. Writ court cannot enforce an OTS proposal, but writ court can direct a private bank to consider it. So Justice Moushami Bhattacharjee passes an order saying that you dispose of the representation, the application for an OTS proposal. That order was not complied with. Till date, my application for the OTS proposal has not even been considered, not touched. Now, I make several applications in this writ petition. I don't go in contempt because there was an understanding enforced by this honorable court. They don't agree to that. You reject it very well. I'll bow down to it. Today, I'm saying that there is a protection that you have. You can take action under SARFACI. But because that mortgage has been created and you're holding on to my title deeds, you return my title deeds. You want to sell off my property, you sell off my property. So this is the first aspect. I'll take your lordship through the orders. The second aspect, which would come in the mind of the court, is that today, if that mortgage has been created, how can they return that title deed to me? That's the obvious question. When the client came with the that was the question I had. I adverted to my lord, section 1313 of the SARFACI Act. Lordship kindly takes that provision once. Why that can be returned to? I'll just take your lordship through the act once. 1313 says, no borrower shall, after receipt of notice referred to in subsection 2, transfer by way of sale, lease or otherwise, other than in the ordinary course of his business, any of his secured assets referred to in the notice without prior written consent of the secured creditor. Now, there is an explanation in the Bare Act itself, objects and reasons. It says, clause 13, which I've just read, this clause provides that any security interest created in favor of any secured creditor may, notwithstanding anything contained in section 69 or 69 capital A of the Transfer of Property Act 1882 be enforced without any intervention of the bank. So today, 69
without any intervention of the
court.
Yes.
The court, of the civil code, suit for mortgage, whatever. So what transpires is today, they, number one, don't need the title deeds to cause an auction sale. That's number one. Number two is, they do not. Number two, section 69 of the TP Act, my lord, is mortgaged. They don't need the title deeds because 1313 allows and 13.8 allows them to cause the sale. So you don't want my OTS proposal to be considered. You have flouted the order of this court. You sell off my property.
No, here regarding OTS, you have not sought any order. You just here in this petition, you want a direction upon the respondent number 2 and 3 to deliver the mortgage title deed.
Yes.
To deliver.
This is at the
here OTS is not the subject matter of this petition.
It can be. It has not there. The reason I didn't argue that, my lord, lordship can definitely mold my relief. Lordship directs them to dispose of in accordance with the order passed by Justice Moushami Bhattacharjee, which is appearing at page 42. Lordship takes up 42 once. I'm sorry.
And what the Transfer of Property Act has said.
Transfer of Property Act says it has to be enforced, but this is a special statute. This overrides transfer of property. So today they don't need.
So your reading of section 13, subsection 13 says that the title deed can be released in favor of the borrower.
That's right. That's one. Two is they don't require it for the sale. So you return my original title deed.
Where is the Loan document. Where is that document?
Well, admittedly, the sanction is there. It's also, my lord, annexed. They've issued notice.
So now you say to take a loan when any property is mortgaged to bank, actually what is done?
Title deeds. There are several ways of mortgage. One of them, which is the subject matter here, is mortgage by depositing title deeds.
Yes.
So I have to give the title.
So equitable mortgage.
Yes, equitable mortgage.
Created in the property,
Right.
which is called secured asset, by which process? Keeping the title deed deposited.
Absolutely.
So how, since the loan has been given in this way, how, unless and until the loan is repaid, the keeping the title deed deposited, the loan which was taken can be released?
By section 13. By Lordship is absolutely.
What section 13, subsection 13 says?
13 says, my lord,
that when you have taken loan, avail of a loan or financial assistance from a financial institution, keeping your property in mortgage, then you will not be able to transfer.
Yes.
So long the said property remain under mortgage.
No, under the once the notice
It is a
13.
prohibition upon the person who has created mortgage,
which is me.
Upon the mortgage.
Mortgage, which is the cooperative.
Yes. You read again.
So once, my lord, they issue the notice under 13.2, the charge is automatically
13.2 means you have not
notice, demand notice.
You have not paid the amount. You
There's a
pay
dispute.
thus, otherwise I shall be forced to take possession of the mortgage property.
And now 13.4 has also happened.
Although in this case, generally, when a person gives any land or such and such mortgage to another, then possession is also given. Generally, maybe mortgage is of different kind. Here, bank take possession mortgage of that property, but possession remains with the borrower. Then 13.4, then he take possession. Then 14, I have sold out that property.
By the district magistrate.
Then I shall, so yes, if he feels that he is created obstruction, then 14 will be invoked.
Police protection.
Intervention of the DM and Metropolitan Magistrate or CGM, as the case may be, will be sought. Okay, in this, thereafter property will be put on auction sale.
Now the Supreme Court is saying they can sell without taking possession also. So they sell on an as is where is whatever there is basis. So now it becomes the responsibility of the purchaser to take possession. So they will file a suit from the against the borrower. And so, madam, I am not on any of that. I am saying you want to enforce, you want to sell, whatever you want to do, you do. But you return my title deeds because today.
No, that cannot be.
Mortgage will not extinguish. The mortgage cannot extinguish. The mortgage, because it was.
So so long I have stated, it has no value.
So, Lordship,
you have mortgage the property, keeping the title deeds deposited with the bank.
My lord will record that if your lordship is with me, lordship will record that this will not impact the mortgage.
No.
Mortgage will not be affected at all. Because that, my lord, appears to be, my lord, the concern, and I completely understand that. But today they don't need it.
I cannot rewrite the terms and condition of that agreement entered into by and the bank.
But they have not complied with the order of this court by, my lord, giving me the OTS proposal.
That is another.
That is, or considering it. So they are not interested in this affair at all, the bank. And manifestly not interested.
Mr. Nayak, that is two aspects. One is OTS, whether they are considering your one-time proposal for one-time settlement or not. Despite being so directed by a coordinate bench, that is another issue. Totally separate. Here in this petition, you want a direction upon them to release or hand over the mortgage deed that is kept with the deed.
I am taking my highest case. Worst case, I will ask your lordship to mold the relief.
If everything fails, I'll ask
So you forgo that pair, that I don't want to my title deed back. don't want to get back.
Well, there is a notice which has been received, my lord, in November. But may I, my lord, bring that on record by way of a supplementary affidavit? It's not there because this was
Here, you know very well better than me. You are doing this matter, Satyavati Tandon and subsequently many
Phoenix ARCS.
and Supreme Court has used this order that despite giving order on repeated occasions, the High Court is
I'm not challenging surface proceeding. I am not
Satyavati
challenging.
Tandon, and I can recollect I can recollect the year 2010, volume 8, SCC, page 110. Satyavati Tandon, the Supreme Court has said, when statute has made an alternative remedy, when statute has made,
Section 17.
then court generally will not interfere.
No, I'm not saying, Lordship,
If
exercise the surface proceeding.
you go before the tribunal,
No, if it's there, I am not challenging 13 at all. Whatever happens in surface.
at any stage you can go.
Yes, yes.
13-2 notice has been given, 13-4 notice has been given, that one kind of symbolic poison has been taken.
Yes.
So there is a tribunal, debt recovery tribunal, you go, don't ask the court. Don't ask the court to intervene in this matter.
In that case,
running counter with the proposition laid down by the Supreme Court.
In that case, maybe I'll come back with something.
No,
I will kindly.
I have many matters.
No, I understand.
Okay.
One more matter will not.
I am giving you liberty to approach the tribunal. Whatever given case you have.
I don't want to challenge surface proceeding. My section 17 right is there. It's already been exercised.
Even you can make an application.
The inaction for them,
even
lie with an order of
even
justice.
You can enforce them. You can enforce them to consider your one-time proposal for one-time settlement also.
No, now that there's now there's an order in writ court
by the landed advocate on behalf of the petitioner. Kindly see at the time of the hearing. Kindly see. That is purposefully not annexed in the writ petition.
During the hearing of the writ petition.
With clean hand. Landed advocate attend the hearing, knows everything, knows about the amount of the one-time settlement in 2022.
Date ki
Kindly see, at that point of time, my lord, the amount was 37 lakhs and odd, and the OTS was 21 lakhs. Attend the hearing.
Here, conduct you. In 2022, most probably, Mr. Nayak, it has not been brought to them. In 2022, in the month of June, the outstanding amount was 37.67 lakhs. Based on your pair for one-time settlement of that amount, the bank agreed to settle one-time settlement.
Yes.
21.02 lakhs.
In 22.
In
the year 22, August.
In the year 22.
Now, 25.
On 12th of August 2022. Now, Lordship, they will come forward and disclose an order passed by Contact Cooperative Bank where they have rejected the OTS proposal as per the order of this High Court on 6th of July 2022. They have showed that. So this should have been, then it should have been rejected or they'll pass a formal order.
They gave a hearing.
Yes.
To you.
Yes.
Along with your learned advocate. Yes. At that time, bank expressed their intention to settle all the dues.
No OTS.
Fully and finally.
Mr.
Nayak, you will say. Yes. Fully or finally at rupees 21.02 lakh against outstanding amount of 37.67 lakhs. As on 30th June 2022. At that time, your advocate said, let me take instruction from my client. So how?
I'm
Where
not
is the
denying.
communication after that, my lord? There is no
So they will,
communication.
Lordship, very well.
End of the
Before I
petition
know
or
what your
after
Lordship will take a 49 once, page 49 of my writ application once. Then I'll leave it to my lord. I'll bow down to whatever. Just page number 49 of my writ application once.
At that time, many say.
But just one order, Lordship will take up, my lord. Yes, we look from the second paragraph on. I'll just read, my lord, for my lord's convenience once. It appears.
Okay, ask.
My lord, they have not passed any order.
God. Same thing.
So very well. May I prefer one last Well, on last occasion, matter came up before your lordship on 14th of May. And on that date, your lordship had directed to serve upon the LIC as well as the private respondent. I have already served, my lord. This is the affidavit of service. This may be kept with the record. My lord, matter before your lordship is the petitioner who happens to be the poor widow of a policy holder of the LIC. My lord, after the demise, she made a representation before the LIC because she is having herself as well as a child. When she sought for, a reply was given by the LIC. Your lordship will find that at page 22, reply given by the LIC.
You are the beneficiary of the LIC.
Yes. Myself and my
nominee, bank is said that I shall disburse in favor of the nominee.
Yes, LIC.
It is the
Yes.
dispute.
LIC. Nominee is the private respondent, my lord. My respectful subject.
Have you served upon him?
Yes, he is a.
I'm respondent number 5. I'm appearing for
Nominee.
Nominee.
Who is for the LIC?
My lord, I have served, my lord. Further served in pursuance of your lordship's direction.
Your Lordship, my instruction is we have handed over all the documents to the petitioner herein, and we are ready to sign or signature anywhere where the petitioner wants. Because your Lordship,
So yeah, let the bank or LIC authority directly release in their favor.
yes,
You have no objection.
no objection.
Yes. And you
Because nominee is a mere custodian, your Lordship is well aware of it. And
trustee.
trustee or mere
He will receive on their behalf
and we will hand it
on their behalf and disburse the same.
to your Lordship.
It is your status.
Yes, your Lordship. You should direct them.
There is judgment, single bench judgment of this court. LIC you serve, they receive.
Receipt for document, yes.
London Junior, you have received. Item delivered, I am saying.
That must have been subject.
আসুন আর কি করা যাবে। if the benefit under that policy is extended, amount, the amount, claim amount, under that policy is released in favor of that. Yes,
I'm for the petitioner.
yes.
On an earlier occasion, your lordships adjourned the matter and accommodated us. Kindly hear the matter is a very short matter regarding the appointment of para teacher. Kindly turn to page 33.
Mr. Ritesh Kumar Ganguly appearing for the state. He is not in the court, my lord, due to some medical emergency. Kindly take this matter on Thursday, my lord.
Emergency.
Medical emergency, my lord. Kindly take this matter on Thursday.
How can I oppose? That is your
Thursday.
Thursday, my lord, I have some personal difficulty, my lord. I will come late, my lord. Any other day, my lord, Wednesday or Friday.
Wednesday korun na, right, madam?
Or Friday, my lord.
Friday, my lord.
Friday.
It's on the top, my lord, on the top. As
No, for order. Friday under the heading for order. Okay.
Faithful, my lord.
Extension of interim order দেখি।
Get to
হ্যাঁ।
32,
31, 32. Taken up without any gated
Ah,
order was passed.
32 and 33.
32 and 33. I'm sorry, man.
Yes.
The interim order is expiring.
My lord, Mr. Anirban Mitra is appearing on behalf of the Union of India, my lord. My lord, he's out of station, my lord. My lord, kindly extend for a short period of time and fix a date for my lord.
In the disposal?
No, my lord. No, my lord.
I do not mind,
No, my lord,
the
no, my lord,
matter
no, lord.
is kept in the list, my lord, for final disposal.
No, my lord.
Interim order,
I'm
I'm
objecting,
telling
my
my lord, your lords will find
because Mr.
what I have suffered this time also.
My lord, then kindly take it on Thursday, my lord.
I had to write this letter. I had to write this letter because on earlier occasion, I believe
because
my
I'm
landed
not
friend-
in the panel, my lord. So
আচ্ছা, an adjournment আপনি লিখুন তো, an adjournment has been sought for on behalf of
typing the case number by the court officer.
Oh, case number ভুল হয়েছে আপনি
No, not this time. That was there for that reason, my lord. Despite my lord mentioning, my lord, the matter could not be listed before my lord Justice Basu.
Oh.
I mentioned. Then, my lord, for correction of cost, that case number, my lord, it took about 10 days. I had to take out 2 applications. Your lords will find from the order of Justice Basu, Vishwajit Basu. And it was prior to my Kaushik Chandra's court, my lord, it was done. Initial order was passed by my Justice Subsidy Bhattacharya. Every occasion on hot contest, my lord, these injunctions were passed.
Okay. উইথ করে করবেন অর্ডারটা, হ্যাঁ, উইথ একটাই অর্ডার। ইয়েস 34
Lordship, I appear for the petitioner. Lordship, the counsel for this matter is before another out of station. So, Your Lordship, I pray for a note this week. Lordship, it's regarding the prevention of cruelty against the cattle Act, and Your Lordship has passed an interim order which is subsisting till the disposal of this criminal revision.
So there is no urge to praise the matter.
So, Your Lordship, I just pray for a note this week. Since the council is presently out of station, Your Lordship.
As paid for, আচ্ছা ওনার নাম লিখে দিন আচ্ছা an adjournment has been paid for on behalf of the petitioner ঠিক আছে আচ্ছা ওনার নামটা লিখে দেবেন ইয়েটা স্টপ আচ্ছা the learned advocate representing the state did not oppose such fair ঠিক আছে in view thereof list the matter in the monthly combined list combined monthly list of August.
Much obliged, Your Lordship.
August?
Yes, Your Lordship.
In the combined monthly list of August. Contested application. Under the heading contested application. Whether it has been parted or it has been assigned to this court. It has been assigned. Okay, yeah, I can recall.
Any day, it will. I'm having.
তাহলে ইয়ে করবেন in the monthly list of July করে দিন monthly list of July. Okay, it has been assigned matter.
Yes, Your Lord.
It has been assigned. Yes. Next.
35. I'm for the petitioner.
Again another.
I'm for the opposite party number 1, my lord.
What is the matter about? Yes, what's the matter about? Yes.
The case was filed in the year 1998, but disposed of in the year 2010. Over.
This is a second division. Almost second division.
Issue over selling of copyright in respect of feature film done. Assignment of copyright. Actually, what happened? The respondent, Bhavan Agarwal, who claimed himself to be the producer of feature film Dana, approached us, approached the petitioner, and thereafter an agreement to that effect was signed in the year 1997 on conditions that prior to release of the feature film, 15 days prior to release of the feature film, a good print of the said film to be supplied to the petitioner for converted to video, cassettes, etc. But the other feature is the film was released earlier. Thereafter, it was handed over, but it was converted to video cassette. Soundtrack was displayed. Defective. That's why petitioner sent letter. But the trial court did not believe those. Exhibit A, Exhibit B. And thereafter, when the petition
three checks of rupees 1,80,000 were issued by the petitioner in favor of the
Opposite party number 1, my lord.
Opposite party number 1.
Complainant.
That all those checks have been dishonored. The learned court below has relied upon the presumption available to it under section 139, yes, 139, and relied upon such a judgment. So what wrong the?
Definitely there is wrong.
Yes. So
First of all, case of dishonour of check, there must be existing liability. Existing liability is a condition precedent filing a complaint case. But in the complaint case, there is nothing about existing liability, no whisper. Then it was revealed that the assigner who assigned the feature claims certain right to the petitioner was of motive of cheating from the earliest time, because he represented himself to be the producer of feature film done up, but he was not the producer. Kindly see the.
oh, why you are taking the court to the fact? Now it is totally whether any illegality, impropriety, or incorrectness in the judgment or not. It is a revision, not is a fact-finding authority. Now we are saying that the court did not consider that there was with aspect that whether there was a existing liability or not. Actually, burden of proof lies upon whom? One presumption is there.
Presumption is there.
So burden will be reversed upon you to show that there was no liability.
It was shown. The registered letter posted, handed over, was the distract of defunct of soundtrack, but that was disbelieved. Exhibit C, there was a postal receipt, postal return, all were disbelieved. And as a result, but as a matter of fact, the copyright which was sold to the petitioner, it was again prior to passing of the judgment in the year 2004 sold to another person. That means that copyright was not given to the petitioner. Only see,
you brought this fact on record by giving evidence.
It was presented before the Sessions Court, but that has not been referred in the judgment itself. Thereafter, the assigner sold the same feature film, same copyright in the year 2011. If the right was already delivered, how can he sell it twice? That's why I have prepared a written note with supportive documents and referring the pages, if your lordship kindly permits.
Have you given the copy?
My lord, I have not received it.
You give the copy. You are Mr. Dotto. Oh, yes. Yes. Sadhukan. Mr. Sadhukan, at this stage, there is a little scope of entering into the fact. Admittedly, you had issued the check in favor of the OPIP number 1. Check 3 checks of rupees 1,80,000. I am trying to seeking clarification on to clear myself. Now, there is a presumption under section 139 that since you have issued the check, there was a existing liability and to discharge the same, you issued the check. However, this presumption is rebuttable presumption.
My lord,
Now, burden to rebut this presumption lies upon you to show that no check was lost, and at least to prove that there was no existing liability.
existing
Now, in
liability.
revision, there is a scope of appreciation of evidence is very limited.
Existing liability would have been created if the agreement entered into between the assigner and the assignee. Assigner was the respondent and assignee was the petitioner. Terms 5A, the assigner was bound to supply a good print of the feature.
Oh, that is another aspect. If he commits any wrong under Copyright Act, that is remedy slash otherwise. Even you can injunctate the other from using that same copyright. That is your remedies, another aspect.
My lord,
In respect of this matter,
In good faith, prior to release of the film, check was handed over. Post-dated checks were handed over on the presumption that the assigner will supply good print as per the agreement clause 5, but did not do that.
my lord, if there was any breach of terms of conditions on my part, they could have filed any case for seeking damages.
I do agree.
But
I
just
do
because
agree.
there is any breach,
Please,
that does not exist. That does not enter
I am
existing
seeking
liability.
clarification from him. That means I accepted your plea that not. I am seeking clarification from him. Court does not know the fact. Court just looking into this matter. So I am you wait. When your turn will come, then I shall attack you also. Get prepared. So let me attack Mr. Khan only to clarify. So there is a presumption whether you gave this evidence. Question is whether he has committed any breach of agreement or not. Not that. Whether on that date there was any existing liability or not.
Existing liability was not created.
Yes. What evidence you adduce to prove the same?
That's why we have exhibited Exhibit 1, Exhibit A, Exhibit B, Exhibit C. But that was disproved by the trial court.
Have you annexed the trial court judgment? It is revision. You have only annexed the revision. Look, you have not annexed the trial court judgment also. Although appreciation of evidence is not the duty of the revisional court will not appreciate. You file supplementary affidavit. Wrong or compilation will not do. Oh, court want to see the trial court order, judgment or order. Compilation you come, it is for the purpose of argument. But you are to bring the trial court's judgment on record. Otherwise, court cannot see if you object that it is not a matter of record. আচ্ছা আপনি ইয়ে করুন যে আচ্ছা মিস্টার সাদুরকার লার্নেড অ্যাডভোকেট রিপ্রেজেন্টিং দ্য পিটিশনার আচ্ছা being assisted by Mr. It is specially fixed matter. So come after recess. Come after recess. ও 2 PM ম্যাটার হিসেবে ও একটা
respondent in this matter, there was a direction upon the chairman Public Service Commission to file a report regarding the numbers of recruitment process concluded in last few years. Chairman has already filed the report before my lord.
So this is what I recall, my learned friend is saying rightly. The honorable court, by giving and passing in the last order, observed that a sumo report was called from the public. So
That report has been filed.
because this is not a challenging any action of the PSC, it is only for the regularization of the employees, those who are working long years in the temporary, in the contractual post of the government of West Bengal.
You make him party, make the PSC as party.
We are not the necessary parties, lordship. There is no.
Okay, proper party.
Not necessary at all, because I don't have any
There is no grievance against
but
us.
it will only delay the process. But the moot question is that whether the employees who are functioning, those who are engaged in the contractual employment for long years of service from 2008, it is 2025. It is recommended from the department. We are in the Department of Self-Help and Self-Employment Scheme.
I'm applying my mind later on.
I'm just giving a gist of the what I try to convince you lordship. Just
you will get.
They are not having any rule. They are not they will get.
You making party liberty is granted to you. Making party and serve a copy.
Yes.
Okay.
Yes. I do copy.
You have to understand the matter.
Yes.
Hey, chairman has been made party.
No, lordship.
Leave granted by the Honorable Justice.
Oh, 140 করেছিল
Rajsekhar Mantha on 7 March 2024. Chairman is a party. Respondent number 7.
Let me, why not?
চেয়ারম্যান পার্টি করেছে কোথায় গো?
কোনো অর্ডারে করেছে তুমি দাও দেখে বলতে হবে। আমি কিন্তু মনে করতে পারছি না।
Order be served.
হ্যাঁ?
Copy of the order be served.
না জজ সাহেবের ডাইরেকশন অনুযায়ী অ্যাড করা হয়েছিল।
পরে
ডাইরেকশনটা কোথায়?
কোথায় ডাইরেকশনটা কোথায়?
সেটা তো পিটিশনের মধ্যে লেখা ছিল। আমি পাঠিয়েছিলাম।
Mr. Banerjee,
only one submission, my lord. Let them appear. I will serve the copy. Only, my lord. I will not too much of time. It is a very much factual matrix are involved in this case. We are really deprived.
State as seeking extension of time to file affidavit in opposition.
My lord,
a coordinate means directed.
Your lordship can recall your lordship's last order. They took time and prayed for filing of the affidavit, and they challenged the maintainability of the prison. Then I registered that.
Madam, you are Mr. Roy. You are Mrs. Roy.
I'm both are in on list number 4. I'm a junior.
Our learned counsel on earlier occasion also.
Yes, maintainability. Then no, my lord. They will file. I am not saying they will file it. My only thing is that they are supposed to file. Long time has been elapsed thereafter. They challenge the maintainability of the prison.
Yes.
I took a point that maintainability point along with the merits will be considered together. Your lordship pass the direction to that. Now, if it is, my lord, again adjourned today, in futile exercise of time, the employees, those who are engaged now, my lord, they are facing immense trouble. Firstly, my lord, department under which they are working, department is ready and willing to give them regular appointment for various reasons. That I will narrate thereafter. Finance department approval is pending. Only further we are suffering. Not because the department is not all willing. The department with whom we are working, they are ready and willing to give the regularization of the appointment.
So at this stage, there is no scope of passing any interim order.
Not passing any interim order, but the matter should be heard, my lord, at a length.
So let them come with affidavit. State is
they will
preemptively extended.
They were supposed to file by this day. They did not file. My lord, they are, my lord, not taking the proper steps, I think. But I should not use any.
When you will be able to file? At 10 days.
Then I have to file the reply and the matter will be delayed.
No delay.
Or then fix the date
of regularization matter.
My lord, if your lordship kindly, my lord, fix it on any day.
I am fixing
in the meantime,
it.
I will exchange the affidavit.
Where is your report?
একবার দেখে নেবো এগুলো নাম্বারটা নিয়ে নাও আমি তোমার নাম্বারটা আগে রাখি
Item number 36.
36, 37, one my read petition and one Mr.
Oh.
Possible kindly grant me only one because both of my juniors are absent today, Malad.
So time for the state respondent in 37.
Only one day, Malad. Not today, Malad. Tomorrow.
You are 37.
37.
May I just indicate one thing? Whatever, let the matter lay over, let them come with instructions. Today the position is, just do not open the papers. I was placed under suspension in the year 2015. I was governed by the 1972 rules. The 1972 rules, factual position is there is no scope for placing a person under suspension. So there was no scope for subsistence allowance. It was suspension as an incident of service and payment of salary to the full extent. That was not being paid. Good, bad, indifferent on the promulgation of the 2018 rules. From that date, suspension, subsistence allowance. I came to your Lordship's court by two writ petitions. The one writ petition alleging suspension to be illegal, the other, regarding the entire issues. The writ petition stood disposed of by holding that for the period from the date of suspension till promulgation of the rules, I should be paid my entirety of my salary, which has not till date been paid. From 2018 rules, from the promulgation thereof, I will be paid the subsistence allowance. And the disciplinary proceedings, if any, has to be concluded within a particular frame of time indicated in the court's order. Today, in the year 2022-2023, 31st May 2023, I have retired.
Oh, so
I have retired.
A question of
I have retired, and this entirety, no question of disciplinary proceedings today. Today, I am on a very simple issue. I am being paid provisional pension, allegedly on the ground of pendency of criminal cases against me, which dates are given year-wise. Next date in one of the matters is January 2026. Likewise, it is continuing. It will never end in my lifetime, I presume. The ROPA rules of 2019, it prescribes that in the event there is no disciplinary proceedings left, then instead of provisional pension, my contemporaneous increments has to be poured in the scale. Today I am getting a meager 14,000 towards my pension. They are giving it, maybe 1 month there is a delay.
Provident fund they have released.
They have released after a long intervention of your Lordship.
Insurance and Provident fund group
Provident
insurance.
fund, they have released gratuity, leave encashment, nothing released.
Leave encashment.
No. In case of school teacher, there is no provision of leave encashment.
Very well. Let us take it, whatever he says is correct.
The gratuity, whether gratuity would be released or not,
it
is.
According to me, gratuity cannot be stopped. Be that as it may, today the position is, there is no inquiry.
There is judgment of Justice Dotto.
Yes. There is no inquiry.
Single bench.
Yes. Now, what I am respectfully submitting, let my learned senior friends, including the state, come with an instruction. They have filed a report. That is just narration of facts. If your Lordship looks into the report that was filed previously, on the last occasion, that is just mere narration of facts. Nothing new is there. Now, today, a person is getting only provisional pension at the scale prevalent in 2015, whereas, by virtue of the 2019 circular, which I am handing over to my learned friends, I am sharing it with them. Let them come up with, just give me 1 second.
This is February 13, 2019. Issued by the School Education Department, dated 13 December 2019. I shall share it with you. It is in view of the recommendations of the 6th Pay Commission constituted by such and such. Date of effect is 1st January 2016 notionally, with actual financial effect from 1/1/2020. It in paragraph whatever paragraph or clause 7 says, in 7.2, 7.2, the top portion. Kindly sees,
Yes.
I am reading it for your lordship.
Here.
The employee under suspension shall continue to draw subsistence allowance.
Yes.
Based on existing pay structure.
Very well.
And
then
in the revised scale shall be subject to the final order on the pending disciplinary proceeding.
There is no pending disciplinary proceeding. There is no, so then the amount of subpara 1, the pay shall be fixed. I am only on the question of fixation of pay adequately, whether I am entitled to the balance, the arrears, that will be examined by your lordship. Today, if this fixation takes place because of no proceeding, nothing, then what happens is, my pension will be fixed at the salary to which I would have been legally entitled to at the time of my demitting office. And then, my pension from 14 would have jumped to 48,000. So, this instruction is required. If your lordship wants, I can place this by way of an affidavit. I can circulate it to all.
Whether have you bought the Payment of Gratuity Act?
Yes.
Payment of gratuity, and most probably there is another circular. That means for provisional pension during pendency of the criminal case.
Yes, madam.
Criminal proceeding. Gratuity should not be released.
Yes.
They can withhold the gratuity.
I have placed that.
And the provisional pension or interim allowance.
Yes.
The word.
This is West Bengal Services Death Cum Retirement Benefit Rules 1971. It says in paragraph 8, Rule 8.
Yes. Yes, Rule 8. Yes.
DCRB rules 19 clause 5. That is applicable in the case of the petitioner.
তোমাকে পাঠিয়ে দিয়েছি যে সার্কুলারটা দেখালাম 2019 যেটা দেখালাম হ্যাঁ প্রথমে যেটা দেখালাম দিদিকে একটা দিয়ে দিও দিদির নাম্বার নেই আমার কাছে
যে তোমার রোপার 19 এর যদি ফিক্সেশনটা হয়ে যায় তোমার প্রভিশনটা হাই হবে এটা স্টেট ক্যান
স্টেট ইনস্ট্রাকশন নেই আমি স্টেটকে দিয়ে দিচ্ছি এটা কপি দিয়ে দাও না দিদিকে একটা কপি দিয়ে দাও প্রিন্ট দিয়ে নেওয়াটাই তো চাপ আছে দিদি ফোন নাম্বারটা নিয়ে হোয়াটসঅ্যাপ করে দাও please see withholding of pension in cases of conviction and misconduct. First of all, there has to be conviction. This criminal case is going to continue for the rest of my life. There is no charge sheet in one matter. They are producing people to prove that I have attempted murder on someone. Producing witnesses. It was DCRB 1971.
Oh, 71 will be applicable. It's 81 is applicable for you. 71 is not applicable in his case.
81, huh? 81, have you brought the 81?
81 rule 8 to 18 subclause 5. Read subclause 5.
Yes, judicial proceedings, departmental proceedings have been instituted.
Judicial proceedings is pending.
With respect.
And this word has also been used by the Payments of Gratuity Acts also.
Let us assume, a judicial proceeding is pending. Pending means there has to be a charge sheet. Mere pending will not do. A criminal case or a departmental inquiry is initiated by issuance of a charge sheet. Without charge sheet, mere accused in a criminal case will Milord
accused unless declared to have been
again Milord then
unless you are declared to be guilty,
you are innocent.
always accused.
Always.
Guilty, then convicted.
Now, Milord,
Then you will be addressed as convicted.
Now the issue is, today I am on a more elementary issue, Milord. I have shared it with my learned friends. Milord, if they can come with this specific instruction or stand as to whether in view of pendency of the criminal case is one aspect. In view of no departmental proceedings against me.
No, there is no scope. Since you have retired, master-servant relationship has ceased.
So today,
there is no
turn the
scope.
clock back.
Yes. There is
Therefore,
now the authority, pension sanctioning authority, has got the power to withhold the gratuity and pension.
Very well.
And pension.
But my pension has to be refixed at the scale in which I would have retired had there been nothing against me. That is the Milord sum and substance of what I have shown your Lordship, Milord, by dint of that iPad circular.
So I am trying to find out that circular when 2/3 of the pension, that circular, give that circular. And Mr. Bhattacharya, there is a judgment of Justice Dotto. There is judgment of the Justice Dotto. Even Justice Dotto held that discussing all these things, even gratuity can be released. Single bench judgment. I got the occasion to see.
Gratuity can be released if the criminal case not relates to his service. Here, involvement of financial liability.
Your Lordship, on one occasion, it fell from your Lordship. The financial impact, according to them, is a lakh. So today, Milord, the entire amount can be released, Milord, withholding the amount that they say is allegedly involved. So ultimately, conviction.
Provisional pension and interim allowance. Interim allowance may extend to 2/3 of the pension. Yes. That circular being that. Bring that circular.
Keeps it not
more than the regular.
My learned senior friend.
Yes.
Pension should not be more than the regular pension.
So it cannot be.
Yes.
No, so tomorrow, kalke.
No, the state still for regular. Whether state can refix his salary or enhance the.
Next Monday, Tuesday. Next Tuesday, could it be your Lordship's gracious pleasure?
Okay, no, the time is available at 2 p.m.
That particular instruction from that circular is also.
Circular judgment, you bring that judgment, and that circular interim allowance or provisional pension interim allowance to 2/3, that bring that circular. And also the payment of gratuity.
Very.
কবে ফাঁকা আছে একটা দেখুন না 2 PM ফাঁকা আছে ফাঁকা খুব মুশকিল হ্যাঁ 2 PM 24th, maybe 24th July.
Not any other day, Milord, on the regular course, if it comments to your Lordship.
21st.
21st July. Oh, 21st July,
21st July, Monday.
21st. But I have no problems.
24th. Okay, had the learned advocate appearing for the respective party list the matter for further consideration on 24th July at 2 PM.
Very well. But 24th July at 2
mention
PM,
the specific provisions so that I can inform to my client.
And I have shared it with her.
State respondent, kindly mention in your Lordship's order, the specific provision. I shall take the instruction from my officer.
You know very well. You try to find out, you will get it.
Paragraph 7.2 that I invited your Lordship's attention, kindly please ask.
There is no indication.
I am to record what submission they have made.
Not supply the specific provision. Kindly mention this. Otherwise,
kindly in your Lordship's order record that I have made one submission regarding paragraph 7.2. They are to take instructions on that. Whether my pension can be refixed at the enhanced rate. Nothing else. দাও তো সার্কুলারটা দাও না, my lord.
That one sentence will be sufficient.
Yes. One sentence. Lord, this circular, paragraph 7(2).
It is a circular of
Lord, it's a
DRB 71.
yes. No. This is Milord 2019 ROPA by
Oh.
the School Education Department.
আচ্ছা আচ্ছা তা দাঁড় করে দেওয়া
Grateful, my lord.
Yes.
Instruction
এই
দেয়া
তো
যাবে
ফেরত
না।
দিবি।
আটকে দেবে না। 21 তারিখ 21st জুলাই 24 জুলাই
ও আচ্ছা আচ্ছা year for 38. Oh, the record is not available. Pass over, let him find it out. Yes.
39.
Petition.
Yes. Restoration.
Restoration.
Copy has not been served.
You have not served the copy.
আর বলছে কপি আমাকে সমস্যা
হয়ে থাকে
একটু তাহলে একটুখানি হ্যাঁ না
Whether there is a delay.
But there is a delay. But that's why separate section 5 application is there. 184.
84 days. 184 delay, madam.
But the crux is not very short. The proceeding initiated under Act 2. Lord, your lordship knows under Act 2, Lord, there is a provision that payment of ad hoc Lord, compensation without determining the award, they can take possession. That was being done. But Lord, after all, in 2008, one of the land loser, he came before this honorable court. It has been found that though the Act 2 proceeding lapse, thereafter 93A for revival of Act 2 proceeding was being initiated, but since the requiring body did not place the fund, so ultimately award was not declared and that 93A also not been concluded, so it has not been converted to Act 1 proceeding. Now in the meantime, Act 1 has also got lapse. So
Now 13 Act.
Now 13 Act.
You want compensation under 13 Act.
That's not that. And the RTI information in the year 2016 annexed to the writ petition suggests that no award declared at least at that point of time also. So, Milord, it is an apparent case of that. So now, Milord, the restoration has...
My lord, the main contesting party is the state. I am the requiring body, the South Bengal State Transport Corporation.
Have you placed the fund?
I have given... I have used my affidavit in opposition. I have annexed all the documents that I have given to the...
Who is appearing for the state?
State is the original.
Answer Mondol, Milord, I have served to him also. Milord, I will send Milord again a notice, Milord, that there will be no difficulty.
Okay, whether there is any interim order?
No, Milord, there is no, Milord, no scope for any interim order, I say.
I mean, can 2 of 2020
different is for the requiring body. In 2008 writ petition, one of the land loser came where that writ petition, the requiring body said that yes, by way of an out and out sale, we shall take the land from him. So that was done. Lord, that order is also there. And Lord, in the
You are agree.
that Lord, my
If the requiring body directly purchased from you, you are agree.
Presently, we don't have any instruction for direct purchase.
You take instruction.
because that
So
was
that
done
is
in
not
respect of same acquisition case.
তাহলে আমাকে instruction দিতে
I
হবে,
annex
আমাকে
করা আছে, written.
Because madam, you knows very well.
At that point of time, we have
Now
to-
both the acts have lost their lives.
And Lord, the Honorable Supreme
Okay.
Court has now made it clear.
Yes.
But
You know, now 2013 Act, 24, Section 24. You know, now you have to pay compensation as per the provision of new Act.
Yes, my lord, if they
New
prove
Act.
their case, my lord, if your lordship can, because it is not, we don't have any instruction for direct purchase in this matter, my lord. That is not.
No, no, in respect of other similarly situated candidates,
That is
and
also
of similarly situated candidate, you have done it.
But I shall take instruction regarding that matter
Oh,
also,
okay.
because I don't have.
Okay, আচ্ছা।
Any day, Lord, your lordship.
আচ্ছা, আপনি ইয়ে করুন, এবার রিট পিটিশন আপনি ইয়ে করুন, রিট পিটিশনের অর্ডারটা দিন। আচ্ছা, স্টপ। Heard the learned advocate appearing for the respective parties. ঠিক আছে, stop. আচ্ছা, yes. Yes, 38 got file located. Who is your other side? He has left the court. 38. So possible. কারণ সে ছিল তখন। সে বলল আপনি হ্যাঁ, yes.
Patterns, my lord, are related to the higher scale of pay, my lord.
Higher scale of pay.
Petitioner has completed all his classes before joining, my lord.
Petitioner?
All his classes before joining. Just practical examination was.
But pursuing postgraduate course before joining. Yes.
Past November 2013.
So I pass order on this issue.
It is, he has not got the higher qualification in the relevant subject matter.
That's why
Yes.
I got the mathematics and the applied mathematics. In my lord, the honors skill, my lord, I enjoyed mathematics.
He has done.
But my lord, MSc, my lord, there was a two part, my lord, pure mathematics and the applied mathematics. Both are the relevant to the mathematics subject matter.
Okay, so yeah. What is the writ petition? You have annexed another writ petition.
Earlier on,
The entire writ petition you have annexed.
PS 77 in full order.
What kind of you show your appointment letter in which subject, which group you have appointed? Recommendation.
Indicating the approval matter.
Supplementary affidavit. Now, my lord, he is handing over the supplementary affidavit to.
Approval order, my lord. Just, so not annex.
You joined in which group?
Mathematics, science and mathematics.
Mathematics, science group in mathematics. Science group mathematics. Okay. Now you obtained postgraduate degree in which subject? Mathematics.
Applied mathematics.
Applied mathematics, not with optional.
In MSc, my lord, the mathematics in the two part, pure mathematics and the applied mathematics, which is relevant to the mathematics subject, my lord.
Your higher secondary school, whether applied mathematics is taught in higher secondary school. I don't know. I am not expert. Court is not expert. So you approach the district inspector of school.
He has passed the reason order at
Reason order that it is not a relevant subject.
Relevant subject one, and another point is he has not taken
Prior permission.
prior permission.
Prior permission.
Now the
Utpal Kanti Karan.
Utpal Kanti Karan's case.
Another 2016 amendment. I was appointed.
I am inviting affidavit from them.
Yes, well, no affidavit has been filed.
The court has no expertise to declare as to whether applied mathematics and pure.
Appearance to 11.
40.
Item number 40.
Make resolution.
My lord, item 40, my lord, I beg to appear virtually, my lord. My learned junior is there. My lord, here, my lord, kindly have a look, my lord. The last orders, my lord, on 9th September order and 14th February order, my lord. This is income tax matter, my lord.
Yes.
My lord, kindly have a look, my lord. 9th September order, my lord, and my lord, 14th February order, my lord.
Yes.
Here, my lord, I am challenging the assessment order dated 21st March 2023, passed under section 147 read with section 144(4), read with section 144(b), capital B of the Act. Here, my lord, in the show cause notice, they gave only 4 days time. My lord, law says that departmental SOP says that 7 days minimum. So there is violation of principles of natural justice, also violation of law, my lord. Very small issue. Let the matter be remanded to the authority and giving me chance of filing of reply and opportunity of personal hearing, my lord.
No, my lord, this is not so. If my management conclude, my lord, I shall indicate how this process have to be done.
My lord, kindly have a look at page 104, my lord, of show cause notice.
Okay, show cause notice, it is on 13.
Yes.
Show cause notice on 13.
Yes.
13 March, my lord, page 104.
Now 7 days notice is required to be given.
Yes, my lord. And
for that provision only.
No.
Yes, my lord. I am
That's-
requesting
but
my
prior
learned
to that, my lord-
junior, my lord, to show the SOP. To hand over
SOP, standard of procedure, that is another aspect of the matter.
Yes, my lord. Kindly then, my lord.
Whether law has says
My
that
lord.
7 days notice is required to be given or not.
Yes, my lord. I am showing, my lord. My lord, my respect.
Standard of procedure which they have formulated, whether it has statutory force or not, that is another aspect.
My
So
lord.
a long hearing is required.
My lord.
Now, you are claiming that I have only got 4 days time and hence I could not submit the reply, befitting reply to the show cause notice.
My lord, kindly have a look at, my lord, section
So
144 capital B, subsection 6, clause Roman 7.
Oh,
I am requesting to hand over my book, my lord, with learned junior, my lord. 144 capital B. 144B is, my lord, procedural section. Kindly have a, my lord, first 144 capital B subsection 1, my lord, first. May I read, my lord?
Okay. You just show 7 days notice is required.
I am showing, my lord, law is silent, my lord. Law is silent. Law is only saying that show cause notice. When, my lord, law is silent, your lordship knows very well, then, my lord, rules of natural justice has to be applied. Then, my lord, to cover this issue, they issue SOP. And followed by this SOP, our coordinate bench, my lord, on the similar fact of circumstances, pass the order. May I show that judgment of the coordinate bench, my lord?
Yes.
Silekha Banerjee judgment. I am requesting learned junior to submit the judgment of Silekha Banerjee. My lord, para 7 of the judgment. Similar fact, my lord, is squarely applicable, this judgment. May I read, my lord, para 7?
Yes.
From the show cause notice issued on the petitioner, it would transpire that the said notice has been issued February such and such. The petitioners afforded an opportunity to respond by hours, hours, such and such. At the first blast, although it would appear that 7 days had been provided to the petitioner, however, upon scrutinizing the said notice, it would appear that such notice had been digitally signed on February such and such around 8:37 hours. As such, it cannot be said that petitioner was afforded 7 clear days notice to respond. Thereafter, my lord, para 8, this is important. It appears that in terms of section 144 capital B, subsection 6 clause Roman 7 of the said act, in a case variation is proposed in the income or loss determination proposal or the draft order, an opportunity is required to be provided to the assessee by serving a notice calling upon the assessee to show cause as to why the assessment should not be completed as per such income or loss determination proposal. Admittedly, in this case, it would appear that respondent had issued such notice. However, such notice is not in consonance with the standard operating procedure. Assessment unit under the faceless assessment provision under section 144B of the said act, which has been circulated by notification dated 3rd August 2022, para 9, my lord. It would appear in terms of clause N 1.3 of the standard operating procedure. It has been provided that the principle of natural justice must be followed. In clause 1.311 thereof, the response time for the show cause notice has been identified as 7 days. So, my lord, in my case, only 4 days time given. And, my lord, Honorable Court, my lord, coordinate bench, my lord, set aside and remanded the matter to the assessing authority, my lord. And para 12, my lord, as a sequel thereto assessment order dated such and such for the assessment year such and such issued under section 147 read in such and other consequential notices dated such and such are accordingly set aside. May I submit, my lord, the SOP, my lord? My lord, SOP, my lord, kindly have a look. Internal page 10, my lord. Internal page 10. Middle portion, my lord. May I read, my lord, para N.1.3? To ensure adherence to the principles of natural justice and reasonable opportunity to the assessee, timelines to be given for obtaining response to SCN shall be response time of 7 days from the issuance of show cause notice. Response time of 7 days may be curtailed if in view of limitation date completing assessment. In my case, there was much time for limitation, so 7 days is minimum, my lord. And therefore, my lord, may I submit another judgment of Karnataka High Court, my lord?
Yes. Here,
my lord, only 5 days time given, my lord. Here also, my lord, the entire judgment is squarely on the fact, my lord. Para 3, my lord. May I read?
Yes.
Attention is drawn to the clause N13, which observed that at the time of response, show cause notice ought to be 7 days from the date of issuance of show cause notice. Para 3, my lord. Then, my lord, para 6, my lord, that it is for the natural justice, it is set aside to the department, my lord. Para 6 and 7, my lord. Now, my lord, I am drawing, my lord, your lordship kind attention, my lord. Once, my lord, section 144 capital B, subsection 1, my lord. I am requesting learned junior to hand over my another book. 144 capital B, subsection 1, my lord. May I read, my lord? Also, I am carrying one printout. I am requesting.
Yes. Printout, give me the printout.
Downloaded from the taxman online, my lord. That will be convenient. 144 capital B.
Yes, I've got it. Yes. Notwithstanding anything to the contrary. Yes.
Yes, my lord. Not anything to contrary contained in the Act, assessment, reassessment, recomputation under section 143 or under section
144.
144 or under section 147. Now my point come. My case is 147. So, my lord, this Act amended. First, my lord, this faceless provision, my lord, comes from Finance Act 2021. Thereafter, 147 was not there in 2021. In Finance Act 2022, this is amended, and reassessment under section 147 is very much under the ambit of 144 capital B. So, whatever assessment that, my lord, whatever the procedure, the faceless has to be followed. Now, my lord, I am drawing lordship kind attention subsection 6, my lord.
6.
6, subsection 6, clause Roman 7.
Yes.
My lord. Here, my lord, in case where variation is proposed in the income or loss determination proposal or the draft order, an opportunity is provided to the assessee by serving notice calling upon him to show cause as to why the assessment should not be completed as per income or loss determination proposal. The assessee or his authorized representative, as case may be, request for personal hearing and to take his oral submission for a present his case before the authority. Now, my lord, this is a very important law. This is the fiscal statutes, my lord. When there is a small adverse decision, civil consequences, then, my lord, time has to be mentioned. In other act, my lord, other sections also mentioned. But here it is not mentioned. To cover this lacuna, they issued, my lord, show cause notice. And your lordship knows very well that when law is silent, then, my lord, rules of natural justice has to be applied. That is, my lord, why our coordinate bench and Karnataka High Court judgment, my lord, followed that SOP and remanded the matter, my lord. My respectful submission is that, my lord, the assessment order and consequential to penalty order may be set aside and remanded to the assessing authority, the National Faceless Assessment Center. After giving 7 working days time, I will submit reply. Thereafter, my lord, after giving opportunity of personal hearing, order may be passed, my lord. This is very small submission, my lord.
So, this is an reassessment. First of all, I should indicate what were the special feature of reassessment. Suppose, the income tax return is being filed, that is a regular assessment that is being done generally as we are all accustomed to it. Return is filed under section 139 of Income Tax Act. That return is assessed by the authority under section 143(3). If any order is passed, then that order may be refunded or may be further demand. That order is passed under section 143(3). Now, my lord, the authority have got a very
143(c).
143(3) of the Income Tax Act. That is the power by which, my lord, the assessing officer assess the income filed by the any assessee in respect of their return. It may be found that, my lord, the assessee have actually suppressed the income and, my lord, by the order under section 143(3), assessing officer demands the undisclosed income and the tax thereupon. Now, my lord, there are provisions in the Act under section 147 which empowers assessing officer, my lord, to reassess the income of an assessee where the return has been filed in the earlier year. In respect of a particular assessment year, when return is filed, there is a time limit by which returns are to be filed. After filing of the return, after the return getting assessed, the authority have got the power to reassess those returns which has been filed earlier if any incriminating materials are found, or, my lord, if any income has found to be not disclosed. So, my lord, that part is coming under the provisions of section 147. I would like to, my lord, take your lordship to section 147, which, my lord, empowers the assessing officer to assess the income which escape assessment. If your lordship kindly take the trouble to come into 147, because that is the impugn order before your lordship, and the order has been passed in the year 2023, and now this is being challenged before your lordship by filing this petition in the year 2024. I will, first of all, my lord, prior to this, I shall, my lord, indicate the prayer portion of the writ petition. Kindly see the mandamus that has been paid for. So many mandamus, so many show causes. I shall, my lord, indicate that while, my lord, those show causes are, my lord, alleged to be assailed, they are assailing before your lordship. There are several occasions where, my lord, this assessee has been provided opportunity to say whatever he has to say with regard to those show cause notices. None of those, my lord, have actually suffered any irregularities. My lord, I shall come into the SOP that has been shown to your lordship, whether that is a law or whether that will create any right in favor of the assessee to challenge that, or that merely act as a guidance to the departmental proceeding and the departmental personnel to carry out any statutory obligations. That is something, my lord, which is also required to be looked into. Now, my lord, our High Court, the Honorable Division Bench,
But you have adopted the same.
I have no. That
unless there is some compelling reason, you cannot deviate from the same.
But that whether that will create any right, and whether, first of all, whether that, my lord, CBDT circular that has been shown is applicable to the case of the assessee or not, that is something, my lord, which is also required to be looked into. Because this is an reassessment procedure. 144B, my lord, that is being shown to your lordship, that is where, my lord, the faceless assessment was first time introduced after COVID. 1st April 2021 is the date, my lord, from which by effect of the Finance Act 2021, assessment has been made to be carried out faceless, in a faceless manner. So that is something which is a procedural point. But prior to that, I am, my lord, thrusting on the point that this is a reassessment procedure. My lord, it cannot be a routine procedure for the department, my lord, to pick up any return and to reassess it. There are several steps prior to doing that. Several steps of, my lord, providing opportunity of hearing, my lord, abiding, my lord, the principles of natural justice are there. So, my lord, I shall, my lord, indicate there are as many as 10 notices that has been served upon the assessee, my lord, asking him to, my lord, say whatever, my lord, the materials which he has to say in respect to my proposed variations of the assessment. So, my lord, first of all, if your lordship kindly turn to, my lord, the prayer portions of the writ petition.
Then, my lord, I have to submit others also, other part of the writ petition, my lord. Let my learned friend submit, then I will submit for the other part, my lord.
Your lordship would find it at page 43. That is, my lord, the prayer portion.
Yes.
There's so many things, my lord, that has been
certiorari, yes.
everything, my lord, all the notices. If your lordship see, the prayer doesn't fit in the page. Page 44, your lordship, kindly see the dates of the notices that has been assailed before your lordship.
My lord, I have challenged, my
Can you
lord,
kindly
entire
also take
proceeding.
note?
Entire
I believe, my lord,
proceeding.
when my learned friend was submitting, I did not oppose him or object.
No. Sorry. I'm sorry.
Actually, he has challenged the ultimate. He has placed the challenge. The
Middle portion, my lord. Middle portion.
Order dated 21st March 2023.
Yes, that is the assessment order.
On the plea ground that a so-called notice was issued upon him on 13th March 2023, calling upon him to show cause on 17th March 2023.
Yes.
That is 7 days notice you have not given. Although you have adopted a standard of procedure that 7 days notice that should be given.
I shall deal with that aspect because that standard of procedure, my lord, I have got an occasion, my lord, to argue on the SOP before the Honorable Division Bench presided by my lord Chief Justice, wherein his lordship held, the Division Bench had held that SOP does not have any binding on, my lord, the assessee, my lord, to claim any right with regard to, my lord, the proceeding. So, my lord, that is one aspect I shall indicate, my lord,
So
that is SOP. But prior to that, my lord, kindly have a look, my lord. What is
I am just called upon to decide this issue.
Yes.
You saw
I should,
a single bench judgment has been placed.
Yes.
Single bench judgment has been
that have a concurrent value to your lordship, but the division bench binds your lordship.
Okay, yes. So a single bench has taken note of such, take cognizance of the same SOP.
Yes. This is, my lord, the judgment pronounced by our division bench, my lord, on 6th of May 2025. My lord, I had got the occasion to argue.
Sir, kindly hand over one copy to my learned junior.
Unreported.
Unreported. This has been just might have been reported, my lord. I'm not aware of the citation. It was passed on 6th May 2025.
Yeah,
the relevant pages.
11 portions. Take me to the 11 portions.
My lord, I'm placing that. From paragraph number 5, my lord, I'm placing. We have elaborately heard the learned senior standing counsel appearing for the appellant revenue.
Again, you take me that portion that the standard of procedure will not confer any right.
That is the paragraph, my lord, I'm reading. That is the paragraph. It appears in the mid of that paragraph.
Okay.
We have elaborately heard the learned senior standing counsel appearing for the appellant revenue and carefully perused the material placed on record and the reasoning given by the learned tribunal. The appeal was filed by the assessee before the learned tribunal challenging the order passed by the National Faceless Assessment Center dated 12th April 2023. By the said order, the appellate authority confirmed the findings recorded by the assessing officer in assessment order dated 25th September 2021, passed under section 147, read with 144B of the Act. This is exactly the case over here. Before the learned tribunal, the assessee contended that the assessing officer has only acted on the information received from the investigation wing and has not recorded his satisfaction, nor did any exercise to examine the transactions done by the assessee before recording the reasons for reopening. The learned tribunal did not go into the merits of the matter, but relied upon the instructions given by the CBDT dated 10th January 2018, which deals with the standard procedures for recording satisfaction under section 147 of the Act. After referring the said instruction, the tribunal came to the conclusion that the assessing officer has not adhered to the standard procedures as he has only referred the information received from the investigation wing, and the assessee is stated to be one of the beneficiaries for receiving accommodation entry to avail bogus short-term capital gain, and that is incumbent upon the assessing officer after receiving information from the investigation wing. He should have examined the return filed by the assessee and the information vis-a-vis the computation of income, and then the forms on and then the forms and opinion that the income has escaped assessment to tax. The tribunal held that the assessing officer has not applied his mind for reopening of the case, that too after 4 years, as the assessee has furnished all details of the alleged transactions in his income tax return and has not adhered to the standard operating procedure. Learned Tribunal has referred to a decision of coordinate bench in tribunal case of Jaiprakash Gupta versus ITO in ITO such and such. Now, let's come to the paragraph number 8. The first aspect which we need to point out is with regard to the effect of the CBDT instruction. Admittedly, the CBDT instruction is a guiding note for the assessing officer and not for the assessee. If such is the position, what could be the effect of such standard operating procedure? The said procedure cannot be taken to be a rule or a regulation or a mandatory direction, but it is to guide the assessing officer to proceed in a particular fashion while recording satisfaction under section 147 of the Act. Therefore, the tribunal, in our view, committed an error too by elevating the status of an instruction which is issued to the guidance of the assessing officer to be taken as a rule or regulations which would also be binding on the assessee. So, this is the relevant finding, and this finding is applicable to all the CBDT instructions that is being issued absolutely for the purpose of the guiding the assessing officers and the departmental personnel. That does not create any right in favor of the assessee to come up before a lordship and challenging the action under Article 226 of Constitution. That is one aspect. I'm on the CBDT circular that is being shown that does not say that it has actually covered reassessment, because I'm saying this because of the fact that the reassessment is a very special circumstances. It cannot be done in a mechanical manner, and from 1st April 2021 we have got new law which has actually guaranteed that the assessee must be given adequate opportunity before participating into a reassessment procedure. So I shall wish to take your lordship to section 148. Assessment has to be done under section 147. If I could summarize it like this, but before going into the assessment, assessee has to be called upon to file a return for that year, where the assessment officer is proposing to reopen or reassess. So that return is called upon under section 148 of the Income Tax Act. Kindly have a look at section 148 of Income Tax Act.
This is available in book, not available in the printout,
Yes, yes.
Your lordship had got it, 148?
148, yes.
Issue of notice where income has escaped assessment. So, this is the first stage of assessing an income of an assessee under 147. So, 147 empowers the assessing officer to reassess the income of any previous year. But before doing that, the assessing officer must ensure that a return is again called upon to be filed in respect of that year. So that is 148. Before making the assessment, reassessment or recomputation under section 147 and subject to the provisions of section 148A, the assessing officer shall serve the assessee a notice along with a copy of the order passed, if required, under section 1 under clause D of section 148A, requiring him to furnish within a period of 3 months from the end of the month in which such notice is issued, or such further period as may be allowed by the assessing officer on the basis of an application made in this regard by the assessee, a return of his income or income. I'm skipping the rest part. So, my lord, this is the provisions by which, my lord, assessing officer will call for a return from the assessee for the purpose of reassessment of that year. So, but it has to be done subject to the condition of 148A. So, my lord, 148 148A was not there in the statute book prior to this. So 148A actually, my lord, mandated that there should not be any mechanical opening of, my lord, reassessment of any assessee's previous assessment year's income. So there was a GKW drive set, my lord, there was a Supreme Court famous judgment which mandated that although at that point of time, my lord, statute was silent on this. There was no statutory provisions, my lord, which, my lord, empowers, my lord, the assessee to, my lord, seek for a principle of hearing on that score. Now, my lord, 148A, my lord, that has been incorporated. If your lordship, my lord, kindly turn to 148A. So that is the precondition of the issuance of notice under section 148. Your lordship had got 148A.
Yes.
Conducting inquiry, providing opportunity before issue of notice under section 148. So these, my lord, find place in the statute book from 1st of April 2021, 148A. The assessing officer shall, before issuing any notice under section 148, conduct any inquiry, if required, with the prior approval or specified authority with respect to the information which suggests that the income chargeable to tax has escaped assessment. This is A. Then B, provide an opportunity of being heard to the assessee by serving upon him a notice to show cause within such period, within such time as may be specified in the notice, being not less than 7 days, but not exceeding 30 days from the date on which such notice is issued, or such time as may be extended by him on the basis of an application on this behalf as to why a notice under section 148 should not be issued on the basis of information which suggests that the income chargeable to tax has escaped assessment, and in this case, and in his case for the relevant assessment year, and results an inquiry conducted, if any, as per clause D. So, my lord, clause B, my lord, authorize assessee, my lord, to have the materials on the basis of which, my lord, assessing officer proposing to reassess. So 148A-B, that, my lord, I'll show from the record that notice was given to him. Thereafter, my lord, kindly turn to, my lord, 148A-C. That is the provisions, the very next subclause. Consider the reply of the assessee furnished, if any, in response to the show cause notices referred in clause B. I shall indicate, my lord, in this case, there was no reply, my lord, provided by the assessee. We have issued, my lord, 148AB notice on 11th of March 2022. That is appearing at page 63 to 66 of the writ petition.
148B notice was issued
on 11th of March 2022.
Yes.
That appears at page 63 to 66.
Yes.
Thereafter, nothing was given by the assessee to us. So, my lord, thereafter, 148 AD order has been passed.
No reply once. Oh.
No reply was, my lord, given in respect of 148 AB. So, my lord, thereafter, 148 AD order was passed on 26th of March 2022. That is appearing at page 67 to 70 of your lordship's brief.
148
AD. That is the order. That is the order which formally is required to be passed, indicating to the assessee that on the basis of the materials that has been shown to him, and in considering the reply, if he furnishes any, the assessing officer is of a view that his return is subject to be reassessment. A formal order is required to be passed, wherein assessing officer will open his mind saying that, look, I am not satisfied with the reply because I have got certain materials which suggest that income for that particular year escape assessment. So I am proposing to reassess the income of that year, and I am giving you an opportunity to say whatever you will have to say because these are my materials. So that materials are being supplied to the assessee on the basis of 148 AB. That is the show cause notice.
Yes.
And thereafter, if reply is provided, and if no reply is provided, we will consider independently the materials that is lying in our hand and pass an order under section 148 AD. If your lordship kindly turn to 148 AD of the statute book, that is the power by virtue of which, my lord, the assessing officer will pass an order indicating that the income for that particular assessment year of the assessee is deserved to be reassessed. 148 AD, my lord, I'm placing that before lordship. Decide on the basis of the materials available on record, including reply of the assessee, whether or not it is a fit case to issue a notice under section 148. So 148 is a notice by which, my lord, the assessing officer will invite return for that year again, by passing an order with the prior approval of the specified authority within 1 month from the end of the month in which the reply referred to in clause C is received by him, or where no such reply is furnished, within 1 month from the end of the month in which time or extended time allowed to furnish a reply as per clause B expires. So we have got a time bound by which we need to pass an 148 AD order. We have invited assessee, my lord, to file its reply in respect of 148 AB by, my lord, furnishing him all the materials, my lord, which is on the basis of which, my lord, we propose to reassess his income. He did not furnish any reply, so, my lord, we have issued a 148 AD order that is appearing at page 67 to 70, as your lordship had taken note of. So thereafter, my lord, 148 AD notice has been issued.
148?
148 notice. 148 AD is the order, my lord, ventilating the fact that, my lord, the assessing officer proposed to reassess his income. That has been communicated to the assessee. And then, my lord, 148 is the provision by which
procedure to be followed.
Yes, return is to be filed again. This is in case of a reassessment. So, my lord, assessee might have, my lord, file a return for the respective assessment year earlier when it's as per 130, because they're 139, because there is a timeline by which, my lord, we all, my lord, files our return. But the authority, my lord, have got, my lord, the power, my lord, to reassess that return of that year, and the procedure, my lord, starts by inviting assessee to again file a return. My lord, it is also, my lord, aspect of the principle of natural justice, so that because in 148 AB, we are, my lord, actually canvassing the materials which we find against him, which has escape assessment. So, my lord, we'll bring those materials into his knowledge, and then, my lord, we'll invite, my lord, assessee to, my lord, include those materials and to, my lord, refile its return for the purpose of reassessment. So, my lord, that is 148 AD order and 148 notice, where, my lord, we will invite him to file a return. That has been, my lord, done on at page 71. The 148 notice is dated 26th March 2022.
Yes.
So thereafter, my lord, we have issued 144B notice, because we propose, my lord, to conduct this assessment in a faceless manner. So 144B is, my lord, a procedure by which, my lord, the assessment or reassessment, my lord, can be, my lord, carried out in a faceless manner. So 144B is just a procedural sections, my lord. This is not a substantive law. But, my lord, statute itself, my lord, actually prescribing this procedure. So, my lord, 144B notice was issued on 17th of August 2022.
Yes.
That is appearing at page 73 of your lordship's brief. Then, my lord, we have issued another notice, 142 clause 1. This is a notice
142
clause 1.
Yes.
This is a notice, my lord, wherein during, because now, my lord, we are already entered into the assessment zone. So we are inviting, my lord, the assessee to, my lord, furnish certain materials, certain documents, certain bank balance, certain document relating to his income, so that we can assess it. So this is also, these are the steps, my lord, which is, my lord, bind by the statute to ensure that all the time assessee should be given an opportunity to, my lord, produce all the relevant documents, materials, particulars, so that effective assessment can be done. So 142 clause 1 was, my lord, the first notice that was dated 12th October 2022.
Yes.
Your lordship would get it at page 75 of your lordship's brief. So there, my lord, we have invited assessee to certain query. He chose not to reply to that. Then, my lord, the second 142 clause 1 notice, that was on 26th of December 2022. That was on, that is at page 26th December. Okay. First one was on 12th October, second one 26th December. Nothing was replied. Then, my lord, the third one, that was on 4th of January 2023.
Yes.
Then, my lord, on 10th of January 2023, in between, my lord, the assessee have prayed for an adjournment. And we have granted that. Lordship, kindly turn to page 89 once, because this is relevant since, my lord, the question of principle of natural justice is being, my lord, agitated.
Yes.
Page 89 of your lordship's brief.
Yes.
I'm placing that. This is our reply to his adjournment notice. Notice under section 142 clause 1 was issued in your case on 12th of October 2022 and 26th December 2022. But you have not furnished your reply on or before compliance date. After that, a letter of non-compliance of initial notices issued under section 142 clause 1 was issued on 4th of January 2023. On 9th of January 2023, you have replied, which is as under. Sir, with due respect, I would like to inform you that due to bank server issue, bank employee could not give me any account statement. In these circumstances, I am requesting to you for give me 7 days to collect my bank account statement from bank. You are requested, so then we have given, you are requested to furnish your reply on your request on or before 17th of January 2023 as per notice issued under section 142 clause 1 on 12th October 2022 and 26th December 2022. So thereafter, my lord, again on 25th January 2023, there was another notice of 142 clause 1, my lord, which, my lord, we have served upon the assessee. Your lordship may just kindly note the dates. 25th January 2023. Thereafter, my lord, 31st January 2023. Again, my lord, adjournment has been sought for, and my lord, I have replied. And we have replied, my lord, that is appearing at page 94 of the writ petition. Through our reply dated 31st January 2023.
1 minute, sir.
Then, my lord, 20th February 2023.
1 minute, 1 minute.
After 31st January 2023.
To give reply to to 142.
Yes. This is my lord, this reply which my lord is looking at on page 94. That is dated 31st January 2023. This is, my lord, to bring into record that as per his request, adjournment was earlier. Your lordship had observed, my lord, there was an adjournment that has been sought for, that has been given, so so that he can file his reply. A last and final opportunity, my lord. This is, my lord, appearing at page 94. Wherein, my lord, the authority, my lord, is actually, my lord, according a last and final opportunity to the assessee to furnish all the details. Your lordship would get it at page 94 of your lordship's brief. Last and final opportunity. That is appearing at page 94 of your lordship's brief.
When?
P13, the number of the annexure is P13, page 94.
Yes.
Now kindly see. As per your request, adjournment was given to you to furnish your reply on or before 17 January 2023, but you have not furnished your reply till details on or before 3rd of February 23, as called for by notice dated such and such. Both the notices has been referred. Failing which, assessment will be completed as per details available on record. So, my lord, we have got, my lord, no other opportunity but, my lord, to go with the assessment. Since, my lord, the assessor is very reluctant, my lord, to comply with the notices that has been issued, my lord, one after another, calling for, my lord, the materials that is, my lord, required to be submitted for the purpose of, my lord, carrying out this assessment. So then thereafter, my lord, again on 20th February 2023.
Again on?
That is on 20th of February 2023.
Sir, before that, P14 kindly refer.
Okay, that means your view is that sufficient opportunity was given.
Yes.
Yes,
Because this is that's why, my lord, from the very inceptions, my lord, I keep on trying to point out that this is a reassessment procedure. This is not a mechanical approach of the authority. There are several occasions that is, my lord, required to be, my lord, several times. All the procedural formalities, my lord, are required to be complied with, and your lordship, my lord, sitting in a writ jurisdiction, my lord, is required to see whether, my lord, we have acted in the statutory bound or not.
Okay.
So, my lord, thereafter, my lord, now from 2022, all these notices has been challenged before your lordship.
Okay.
20 orders, my lord, assessment order, my lord. Otherwise, that assessment order is, my lord, appealable before an authority.
My lord.
Appeal, my lord, is a creation of the statute, my lord, wherein, my lord, this order, which is, my lord, the primary subject matter of challenge before your lordship under section 147 for reassessment, my lord, is assailable before, my lord, the Commissioner of Income Tax appeal.
Okay.
My lord, learned friend entered into the entire matter, my lord. So I have to submit, my lord, entire matter, my lord. Kindly, my lord, fix, my lord, tomorrow, my lord, because today I cannot go, my lord, attend due to the water log, my lord.
Oh, okay.
Tomorrow, my lord, first matter, my lord. Tomorrow, first matter, my lord.
Tomorrow, my lord, I have got a difficulties.
Sir, tomorrow, parben na? First up.
Tomorrow, have na. Tomorrow, I have got a medical issue.
The patent petition has been by papering the patent petition, several notices issued by the competent authority under section 147, 144, 144B, and 142.
147 is the note, is not the notice. 147 is the assessment order. 148A and 148 may, my lord, do.
Acha, 147 কেটে দিন। আচ্ছা, and the assessment order made under section 147 of the Income Tax Act have been assailed by the petitioner. Stop. Mr. Roy, learned advocate, repenting the petitioner, submits that a SOCOS notice was issued. Acha. Submits that no adequate opportunity was afforded to the petitioner to respond to the SOCOS notice, and thereby the authority has passed the assessment order in contravention of offending the principles of natural justice. Stop. He submits that the SOCOS notice was issued on 13th March 2023 at about 20:02 hours, and time to respond was given till 17th March 2023 by 18th hours. He draws my attention to a standard of procedure and submits that the respondent himself decided that itself has formulated a standard of procedure and decided to afford response time of 7 notice for the issue of from the date and time of issue of SOCOS notice. However, without strictly adhering to their own standard of procedure. ঠিক আছে? The authority concerned only fixed 4 days. ঠিক আছে? And since such a shorter time was fixed to respond the so-called notice, the petitioner has been highly prejudiced and he has been deprived of submitting reply to that so-called notice. So, he submits that that a coordinate bench of this court has got occasion to deal with such situation in case of Srilekha Banerjee versus Deputy Commissioner of State Tax and others.
Income tax, my lord. Income tax, my lord. That was corrected later. Income tax.
Here you have given the judgment.
Yes, my lord. That order later corrected. That prior to that it was
income tax. Deputy Commissioner of Income Tax and others reported in 2024 ব্যাকেটের মধ্যে 467 ITR তারপর 1 within bracket cal. Stop. He also relied upon an unreported judgment by a coordinate bench of the High Court at Calcutta in a writ petition by number 12923 of 2023 bracketed T, capital T hyphen IT within bracket Sri Choudapolli CD Ajoy C plus stop D plus stop Ajoy versus Central Board of Direct Tax and others.
Malad, that is Karnataka High Court, Malad.
That is
Karnataka High Court.
Karnataka High Court. তো বলুন তো Karnataka High Court. আচ্ছা, stop. You, Mr.
Tilak Mitra.
Mitra. Stop. In rebuttal, Mr. Mitra, learned advocate, representing the respondent bracket income tax authority submits that invites my attention to the pair portion and submits that the petitioners have challenged the legality of almost all the notice issued to him by the respondent authorities. Stopped. He submits that there is a difference between assessment and reassessment of the income tax return submitted by an assessee. He submits generally one income tax return is submitted. He briefly narrates the procedure of assessment and or reassessment of the income tax return submitted by an assessee. He submits that here the respondent authorities took initiative to reassess the income tax return submitted by the petitioner. Stop. He submits that reassessment is done under section 147 of the Income Tax Act. But before reassessment, the procedure prescribed under section 148
A and then 40.
148A and
And
then
140.
148 are mandatorily are to be mandatorily followed. Six. Inviting my attention to the provisions of 148. Inviting my attention to the provision of 144B within bracket 7, he submits that if during inquiry, if it is found, but it appears to the authority that the income escape assessment, assessment, and a variation is required to be proposed, then the assessee is given opportunity to submit a fresh return as per the provision of
148A and then 148.
148A and then
return is filed under section 148. And 148A mandates the authority to provide that opportunity. 148 will come later.
148. The petitioner filed return.
148 return, no.
The petitioner did not file such return. So, he submits that before taking any steps for his assessment under section 147 of the Income Tax Act, the concerned authority conducts an inquiry and under section 148 capital A within bracket A, and thereafter an opportunity is afforded to the assessee by serving him in so-called notice, being not less than so-called notice within such time, being not less than 7 days. Calling upon him to show cause as to why a notice under section 148 should not be issued on the basis of the information which suggested that income chargeable to tax had except assessment in his case for relevant assessment year. He submit in the given case that notice under section 41 capital A within bracket B was given to the petitioner. And he was afforded an opportunity to submit his reply. But however, the petitioner has not submit his reply or response to that said no-cause notice. Then the decision was taken under subsection D within bracket 148 capital A. And thereafter notice under section 148 was given. He submits that subsequently notice under section 142 within bracket 1 was also given to the petitioner on several occasions, but he did not. And upon receipt of said notice on some occasions, he paid for time and paid for adjournment to submit reply. However, ultimately he did not supply any reply to that so-called notice. Thus being the situation, the authority concerned ultimately was forced to proceed under section 147 and reassess the income, of the petitioner
for the relevant assessment
and pass the assessment order. Stop. He cites an unreported decision passed by Honorable Division Bench headed by the Honorable the Chief Justice of this court in আপনার হচ্ছে ITAT capital /241/2022 24 bracket Principal Commissioner of Income Tax 9 Calcutta 9 it would be 9
yes Principal Commissioner
Calcutta versus PL Goenka HUF bracket closed. He submit and contains that the standard operating procedure adopted by the department shall be can at best serve as a guide to the assessing officer. And such standard operating procedure shall not confer any right upon the assessee to claim that any violation or breach of that procedure will render the assessment order invalid. Had the learned advocate appearing for the respective party peruse the materials of the court. Stop. From the submission advanced by both the parties, it is appearing that the Income Tax Act or any provisions did not prescribe any period, period which is required to have any period did not prescribe as jointly submitted, the Income Tax Act does not contain any provision requiring the respondent to issue 7 days notice before making a which notice এটা Sokos notice.
This is Sokos notice just prior to my passing of 147 order.
7 days notice prior to passing reassessment order under section 147 of Income Tax Act. However, a standard of procedure was adopted by the respondents. Stop. And as noticed previously, the Honorable Division Bench in the judgment of PL Goenka HF Supra has concluded that the said procedure cannot be taken to be a rule or regulation or a mandatory direction, but it is to guide the assessing officer to proceed in a particular fashion while recording satisfaction under section 147 of the Act. The Honorable Bench further observed that the learned tribunal had committed error by elevating the status of an instruction which is issued for the guidance of the officer to be taken as a rule or regulation which would be binding upon the assessee. Therefore, a bare perusal of the decision of the Honorable Division Bench would reveal that the standard operating procedure cannot be taken to be cannot be considered to be a rule and or statute. It is just a guideline. Stop. It is also well settled that a person taking but raising plea of violation of natural justice will not suffice. But a person taking this plea has to prove that he has been prejudiced.
Getful, man.
ঠিক আছে, হ্যাঁ। I am relying upon the judgment of Sudhir Kumar, Noriman judgment, Justice Noriman, authored by Justice Noriman, 2020.
My lord.
ঠিক আছে, stop. In the given case, as noticed previously, the notice under section 148, 148AB, and even 142 within bracket 1 were issued. ঠিক আছে, petitioner received those notice, and petitioner did not submit any reply, despite the fact the petitioner took adjournment on several occasions.
Yes.
Thereafter, there is no materials before the court to hold that since no notice and 7 days notice following the standard procedure was given, instead only 4 days time was given to the petitioner to respond. A notice issued under section 147 of the Act was issued. The petitioner had been highly prejudiced. Stop. Rather, petitioner is trying to embank on such notice to throw a challenge to the legality to the reassessment order.
Getful.
ঠিক আছে?
I shall also indicate only one little thing.
Therefore, based on the discussion made in the preceding paragraph and based on the discussion and reason made and set forth in the preceding paragraph, and applying the proposition of the judgment set out herein above, ঠিক আছে, I am of the view that no prejudice is caused to the petitioner. ঠিক আছে, আচ্ছা, therefore no interference is called for in this petition. Stop. However, it is clarified that the reassessment order passed by the authority under section 147 is appellable order. The petitioner may assail the order before the appropriate forum in accordance with law, before the appropriate forum, if there is no impediment, if law so permits.
Yes. That's
in accordance with law.
I also only indicate that the impugn order was of 21st March 2023, and the writ petition was affirmed on 15 July 2024. There is no explanation about the delay even before coming up before this court.
And all the explanation given in the writ petition, my lord. And my lord, kindly allow me, my lord. I thought, my lord, my learned friend, my lord, entered into the entire writ petition. This is not required, my lord. Only confined. However, my lord, I am praying to give, my lord, 1 day time to submit on this entire issue, my lord. That is why, my lord, I am praying.
That means you have not taken aback, or you are not surprised to receive notice.
No, my lord.
You are not surprised. You are well aware of the fact. The proceedings is going on.
My lord,
assessment has been done, reassessment done. Thereafter, you receive notice on several occasions.
No, my lord,
so you are not taken aback on receipt of such notice.
All this submission not
I'm grateful, madam.
Possible, my lord.
The court will see whether you have prejudiced or not.
Yes, my lord. Kindly
Whether
allow
the
one day time, my lord,
prejudice-
then I will submit tomorrow.
Prejudice to defend yourself or not.
No, I am ready, my lord. That
My
SOP,
learned friend has filed an inter-writ petition, so I have got an
subject to
occasion to
correction,
deal with the
that
inter-writ
SOP
petition.
is not applicable in my case because that SOP issued only on the point of incriminating material, not on the point of natural justice. My point is a first violation of natural justice. I myself confined in the second part of the proceedings. That is why I did not enter on the first part of the proceedings. If I enter in the first part of the proceedings, then, my lord, I will show your lordship that every stage natural justice violation. But for that, my lord, physical hearing necessary, my lord, online platform, my lord, all these issues I cannot raise, my lord.
Okay. Paper appeal.
I am grateful, my lord.
Peaceful, no interference with this observation and order. This order is dismissed. Okay.
I am grateful, my lord. I am grateful.
By elevating the standard of operating procedure to the status of a statute or rule. Yes. And it would be uploaded tomorrow. Today it would not be uploaded. Okay.
My lord.
এটা বলা মানে হচ্ছে এরা দেবে না আমি বাড়ি চলে যাবেন নাকি এটা দেবেন কবে
I'm extremely grateful, man.
Yes.
Grateful.
হ্যাঁ 41.
Sushant Kumar C.
But I am for the petitioner, my lord. This relates to higher space scale, my lord.
Relate to
higher space scale. My lord, so let us kindly come to the impugned order. Page 6.
Which for your other side.
But I have served notice. That's why I am searching, Lord. I have served notice.
When you are appointed.
They have received. Before mentioning for upgradation, I served them a notice.
When you were appointed.
But I appointed
2029.
No, Lord. I appointed in 1998. First School Service Commission.
1998 School Service Commission under the pass category.
There is a single examination.
Under the pass category.
Under the pass
category.
Yes.
Okay. So whether ROPA 98, there is a provision that who was appointed under pass category can
kindly look into the judgment of the special bench. Judgment of the special bench.
Utpal Kantikaran. Where it has been stated, you saw?
Yes, madam. Kindly come to page 185, paragraph 272.
Page 185, paragraph
272.
272, yes.
May I read for you? Enhancement of pay on acquisition of higher qualification during the service career is dependent upon the relevant rules operating at the time of acquisition of higher qualification and cannot be claimed as a matter of right in absence of rules. For example, a teacher joined the school with a postgraduate degree and during his service career, the teacher enhanced his qualification and claimed higher scale of pay on the basis of the said degree. The said claim has to be decided on the basis of the relevant rule existing at the time of acquiring higher qualification. If he has joined the school with a postgraduate degree after government circular dated 12 February 1999, he would not be entitled to postgraduate pay unless the teacher is covered by the government order number so-and-so as revised by so-and-so dated 3rd November 2004. But I joined before 1999. My appointment letter is at page. Kindly see, my appointment letter is at page 26 and 27. I joined 20th December 1998. At the relevant point of time, I was Lordship, pursuing my master degree in Bengali. I joined as a Bengali teacher. My can you see my appointment is 27. Can you see the date? 28 December 1998. '26 is my recommendation.
When you have joined,
But the next page is my approval. I joined date of appointment.
date of appointments, 2nd January 1999.
Yes. And the circular came into effect from 12th February 1999.
Okay, what can be done? Yeah. So I'm asking who entered appearance 2017?
Minal Kanti, I have given you lots. The Minal Kanti Ghosh has.
Minal Kanti Ghosh.
Yes. May I stop and notice and come back?
Okay. Or I am asking Mr. Pal to appear.
You lost.
Eh? Achha.
Festival is observing by the court, Maharashtra group number 11.
Oh.
That's it.
Okay, so you give notice day after tomorrow. Okay. As I heard the learned advocate appearing for the yes.
43. Well, I'm hearing for the
Yes.
petitioner, my lord. Well, in a writ petition, an order was passed with regard to my lord, granting me my lord, some industrial, my lord, some benefits under my lord, a scheme, industrial promotion assistant. Now, my lord, that order, my lord, is at page 15 of this application. In spite of the order, my lord, the state has not paid. So, my lord, there are two modes I can, my lord, come and enforce. Either, my lord, knows, my lord, by way of, my lord, execution, which is provided, my lord, for, my lord, under Rule 53 and 53 of the appellate side rules relating to writ petition, or, my lord, by way of contempt, my lord, we have come, my lord, by way of execution. This is, my lord, the, can you also give me leave, my lord, to file a supplementary affidavit, my lord? It contains, my lord, the further orders of the division bench, my lord, which had confirmed this order. Pick up, my lord, page.
Okay, I'm coming just.
Can 2, my lord.
Can 2.
Can 2.
I'm coming.
Can 2, my lord, the order is at page 15. You will find the petition.
You are seeking benefit under West Bengal Incentive Scheme.
Correct.
2013.
Yes.
And Siddiqui is appearing.
My lord, learned advocate general, my lord, appear in this matter, my lord. I am praying for my lord, not today, my lord. He, advocate general, my lord, learned advocate general is not come today, my lord. Kindly, my lord. My lord, every matter, because my lord, one my learned senior friend knows, my lord, one notification, government notification has come, my lord. Already, my lord, all matters, my lord, argument by the my lord, learned advocate general, my lord, incentive scheme. All matters, my lord, relating to the incentive scheme, my lord, argument by the learned advocate general, my lord. Kindly, my lord.
Whether in, before any particular
Malad,
court.
so many
it has
matters.
been
Yes,
fixed.
yes, Malad, division bench, Malad, Honorable Chief Justice. No, Malad, this type of matters, Malad, incentive
No.
matters.
Malad,
Malad,
this matter, Malad, went up to the Honorable Division and came back. Malad, I think my learned friend, Malad, is referring to, Malad, a act, Malad, which has come. Malad, that, Malad, he has to come. And this is
Yeah,
not a
it is
supplementary affidavit.
Supplementary.
This order, Malad, was
Supplementary bid filed on behalf of the petitioner is taken on record. A copy has been served, you have received.
you have served on that. Yes, Malad, we have served.
Oh, copy has been served.
We have served on this.
So on judgment has been passed. So you agree to it that what can be done?
Sorry, Malad. Any day.
I am asking him, agree to
any
it.
date, Malad, fix, Malad.
Mr. Chakraborty.
15 তারিখ?
Mr. Banerjee will not oppose. My lord, I will not oppose. After 15th,
straightforward.
advocate, no,
না,
advocate
না,
general.
next week এ রাখো না, 7-8 তারিখে রাখো না। রাখো না, এসে যাবে তো।
8 তারিখে একটা মামলা already
9 রাখো, 9 রাখো।
9 তারিখ।
পারবে না? তো ঠিক আছে, কবে রাখতে চাও বলো? 14।
14 তারিখ।
এই আপনি দেখুন।
না, 14
How much time you will take?
I will take, Malad, 10-15 minutes.
10-15 and
Advocate General specifically he wants to argue that this is not maintainable. Execution in connection with a writ
That I
petition,
will show.
in a writ petition is not maintainable. He wants to argue that point. He has specifically told me that. That is the only thing. Execution application is not maintainable in connection with the writ petition. That's why,
I don't know what is the matter. So where if any order passed by a coordinate bench, whether any writ petition
Will
cannot
come
be
with-
filed to enforce that order.
I'm grateful.
We'll come with the answers. Advocate General,
Otherwise, what do I do?
I was-
I have the order, Malad, I keep it in the house.
I was only praying for any date after 15th. This is subject to my lord's convenience.
After 15. Hey, আমি after 15 days.
17 বা 18 Malad, 17th or ঠিক আছে? 17th or 18th, Malad, if it's
17.
possible for Malad.
If you want 2 p.m., I am to fix on 28. Before that, if you want 2 p.m., your matter will be first matter at 2 p.m. 28? 2 p.m. নেই তো? আচ্ছা নেই। আচ্ছা ওই লিখলেন আচ্ছা হার মিস্টার ব্যানার্জি লার্নের সিনিয়র অ্যাডভোকেট অ্যাপিয়ারিং ফর দ্য পিটিশনার একজন নাকি না অনেকজন দাঁড়ান দেখি অ্যাপিয়ারিং ফর দ্য পিটিশনার আচ্ছা স্টপ আচ্ছা an accommodation has been paid for by Mr. Chakraborty on behalf of the state respondents. আচ্ছা on behalf of the respondents সাবমিট করুন আচ্ছা stopped in view of this list the matter for further consideration ঠিক আছে as specially fixed matter আচ্ছা on 28th July at 2 p.m.
I'm very grateful.
এই
130 কোটি টাকা দেবেন না?
তন্ময় বাবু হবে
44.
Yes. হ্যাঁ না আপনি তো বললেন
I am appearing for private respondent, my lord.
petitioner is not there. Oh,
Mr.
In this matter, Mr. Sujoy Bandyopadhyay is appearing for Mednipur municipality, my lord. He is on like in another court. I am praying for not today only, my lord. He requested me to.
For private respondent, my lord, Mr. Supratim However appearing, my lord, for private respondent. So, not today only.
come tomorrow. What can be
My
done?
lord,
Today, most of you are busy with your Jagannath Puja. What can be done? In bar. Not today. এটা থাকবে তো উপরে থাকবে তো এগুলো তো উপরেই চলে যাচ্ছে তো ইয়েস নট টুডে
Any day. I have no problem.
45 আর কি হবে হেয়ারিং মামলার 4টে you are for the respondent.
Petition. Oh, I'm sorry. I'm for the petition. I'm appealing on behalf of the respondent, but I'm filing affidavit in reply of the respondent number 2 to the opposition on behalf of the writ petition to the report submitted by the Joint Secretary. And this is my opposition.
Report. You have filed report. You have
Initially filed, thereafter they wanted to file opposition. Opposition, then we have filed reply opposition, report by the state, opposition from our side, reply from their side.
Oh.
Of the report.
Affidavit exchanged by the parties in respect of the report filed on behalf of the state. Report filed by the Joint Secretary, Department of Panchayat and Rural Development, Government of West Bengal, are taken on record. Because the affidavit filed in respect of the report. Parties in respect of the report filed by the yes. Directing responsibility committees to sanction release financial benefit in terms of the such and such area amount of remuneration according to this notification. We were seeking benefits under memo dated 16 September 2011 and
Yes,
20th
may
May
please,
2013.
Yes, may please, my lord. I have a very short point involved in this matter.
Yes.
The petitioner was engaged contractually against a sanctioned vacant post of Gram Panchayat Kormi. So his prayer was subsequently other such candidates of different sanctioned posts were regularized and benefits were given during their period of contractual service. Benefits were given in terms of the notifications issued by the state authorities time to time. But I was deprived of on 2 counts. Firstly, despite having contractually engaged against a sanctioned vacant post of Gram Panchayat Kormi, which has been accepted by the state authorities, I was not made permanent. Secondly, the service benefits were not given to me. These are the only point. I draw your lordship's attention to page 24 for once. Kindly come to page 24 of my writ petition.
Yes.
My lord, kindly see it is of 11th of November 2011. Kindly see at the bottom the name of the petitioner Muhammad Mahiuddin. My lord, kindly see the such date of birth, date of engagement. 2009, and whether engaged as casual daily rated worker, contractual worker, specific casual worker he was engaged in. Number of days in service each year 264. Lordship, kindly mark this date time 264 because it would be seen in a separate notifications where 264 days continuous service is needed for giving certain benefits. And most importantly, my lord, kindly see whether engaged against sanction post. Yes, sanction post. My lord, kindly mark because there would be deviation from the stand on the part of the state authorities time and again, time to time. This is probably the 6th round of litigation. This petitioner is languishing for 2011. And this is the 6th round of litigation where he has come to. Now, my lord, kindly come to page 25. That the next page itself, the concerned BDO of the same development block sent regarding approval for permanent of casual daily rated contractual worker in the said concerned Gram Panchayat. Enclosed, please find here with the report of Pradhan Nizampur 2 submitted to the BDO Golpocket 2 Development Office on 9th of May 2012 for approval for permanency, that would be, of casual daily rated contractual worker of 2 contractual employees, namely Muhammad Yasin Alam, Chitragopal Das, under this block. So, my lord, names were sent for making them permanent in their respective post, as it happened earlier. But in case of petitioner, it did not happen. Now, my lord, kindly come to page 50 and 51. In between, several representations were given. Nothing was done. A writ petition was also filed. Order was passed for consideration of the prayer of the writ petitioner. Subsequent to that, an order was passed. Kindly come to page 48 first. This is the order of the DPRD starting from page 48, relevant portion at page 49. Kindly take from 49 the relevant portion. Issued by the DPRDO, yes. Whereas as per record, that is the resolution taken by the Pradhan, Shahapur 2 Gram Panchayat, dated 24th April 2007, the petitioner is serving as a casual worker in the office of the Pradhan of Shahapur 2 Gram Panchayat from May 2007. And whereas the Commissioner Panchayats and Rural Development West Bengal, with a memo number such and such dated 20th of May 2013, sought a report of such casual contractual daily rated workers engaged at different offices under Panchayat and Rural Development Department under jurisdiction of Uttar Dinajpur district to carry out the order of the Finance Department with a number such and such dated 16th of September 2013, as your Lordship referred at the very first occasion, with a number 20th of May 2013. And whereas the name of the petitioner has not yet been forwarded through from the concerned block development officer to the appropriate authority, hence the concerned block development officer is instructed to send the said name to the appropriate authority at his earliest. My lord, this is being issued by the DPRDO in order to consider the candidature of the petitioner as a to become a permanent employee, to regularize his service, and it has been recorded the name has not yet been sent from the video. So there is an attempt on the part of the state authorities to give the benefit in terms of the notification, as well as to consider the candidature of the petitioner against the sanctioned vacant post, since others have been given the similar benefit. Now, my lord,
Other has been given similar benefit.
I placed, my lord, page 25, other candidates of that video has sent the name, but his name has not been sent. That's why DPRDO was concerned and conscious.
Other service has been regularized.
Others, page 25, I shown video has sent their names, their service has been. That is my representation.
Now, what is the ultimate stand of the state?
Yes, I'm coming, my lord, because it has fluctuated from time to time. I'm showing, my lord. My lord, kindly take page number 85. Yes, yes. Next, yes, my lord, kindly take page 50 for once. Video finally sent, yes, send the DPRDO in terms of the previous order, name of the petitioner, and kindly come to page 51.
You forget of the video, what is the
secretariat
level, what's
no, my lord, I need to show these documents because there is a fluctuation of stand. That is why I'm showing to your lordship.
Yes, yes, page.
Kindly come to page 51. 51, yes, 51. This is after the letter of the DPRDO, what the video is sending to the DPRDO. Kindly see page 51 is very important. Name of the office where engaged Shahapur 2 Gram Panchayat, Muhammad Mahiuddin, such and such, date of birth, date of engagement, whether engaged contractual, number of days service 243 days, whether engaged against sanction post, yes. Yes.
Okay, you have engaged sanction post for more than 10
my lord,
years.
that has been disputed
yes.
subsequently.
Ultimately, what is the stand of the state?
Yes, my lord, kindly come, my lord, kindly come to page 85. That is the decision of the Commissioner of the Panchayat and Rural Development.
Yes.
Pursuant to the order of the Honorable Court. Kindly
Yes.
see, my lord. My lord, I am.
Compliance is such and such.
My lord, kindly take from the paragraph number 2. That is important. It
Paragraph number?
Paragraph number, my lord. See the main paragraph. It starts from. It also appears.
Yes.
It also appears that the petitioner filed this writ petition against the impugned order of the such and such commissioner. This directorate building this float that Sri Muhammad Mahiuddin, the petitioner, was not engaged against any sanction post, and Pradhan had given appointment to the petitioner without approval of the government in connection with WP number such and such. But the undersigned as commissioner in the Panchayats and Rural Development Department does not look after the matters relating to establishment of Panchayati Raj bodies, cell, PRI cell, in the PNRD department, and Sri Somojit Das, Joint Secretary in charge of PRI cell, at present looks after the matters relating to establishment of PRI cell. That is the establishment of PRI bodies, establishment of Gram Panchayat, Panchayat Samitis and Zilla Parishads in this department. And as per para 14 of the Memorandum of Finance Department, such and such, Government of West Bengal, dated 16th of September 2011, the final approval in this regard will be given by the ACS Principal Secretary, as the case may be, of the concerned department after exercising necessary checks and balances and ensuring that any ineligible person does not get the benefit of this order. In view of the above, it is hereby ordered that the matter be referred to Sri Somojit Das, Joint Secretary PRI Cell, to the government such and such to take a decision with approval of the competent authority of this department. So there are two things we are getting from the commissioner's order. First, he holds that I was not engaged against any sanctioned post, but that is contrary to the records I showed to your lordship. One, why I was showing those documents. One. Secondly, he says, despite there is a direction of the Honorable Court, he says, see, I am not the authority. You go before the Joint Secretary. If he has to send me before the Joint Secretary and he has no authority, he ought not to have commented on my candidature without considering the records. He has recklessly commented on my candidature that he is not, and sends it to the joint secretary. If you are not entitled and authorized to take a decision and you are sending it to some other authority, you are not supposed to make comment on my candidature. And he has done it so, prejudicing my case.
Page 88, the
Now,
actually,
special secretary,
the
yes,
special secretary has admitted that you have been engaged as casual worker in 2007,
yes,
and he have worked 240
yes,
days each year, and you engage against sanction post. Okay,
yes.
it has been it, but joint secretary also saying that special secretary that I am not the I am
page 80.
not the competent authority.
Now, my lord, it's kind of
musical chair.
Yes. Now, my lord, I've become a football basically. I've become a football basically. One player to another player, I'm being played with.
I
Order
am not been.
Yes. Then who is the authority?
Special secretary. I am not been the competent authority to candidate.
This
It is the latest stand.
No, subsequent I will show your lordship. My lord, this kindly take page 88 for once. The petitioner was heard on such and such date. He admits the position. Now he says, I am not the authority. Now, my lord, where a common man will go in this way? This
have got your yes, Mr. Pal.
My lord, I have one more submission. Kindly, I have submitted one affidavit. Kindly see this. Now, what they have done in their report, kindly take. They now come up with altogether a new case. My lord, kindly take the affidavit in opposition filed by the petitioner. Kindly see what they have done.
Yes, yes.
Now, the joint secretary again. Kindly take page 8. The first annexure.
Yes.
Kindly see status. My lord, I'm placing the third paragraph. Based on the report submitted, Special Secretary of this department with a memo number such and such dated 7th of October 2021, duly informed Additional District Magistrate and Additional Executive Officer Uttar Dinajpur Jilla Parishad that petitioner Muhammad Mahiuddin such and such is not entitled to get any privilege enshrined in memo dated such and such. All of Finance Department, Government of West Bengal, as the petitioner does not fulfill the terms and condition of those memorandums. It's an absolute non-speaking order. Why I do not qualify? For what reason I do not come within the purview of the notification is silent. Absolutely a non-speaker. Simply says that he is not entitled to get the benefit under the notification. But in my humble submission, he does not say why. Now, my lord, kindly take the next page.
Yes, got your point.
No, next page is important. Another observation. That is what I am trying to show before lordship. One after another shift and juggling being going on.
Yes.
My lord, kindly see the next page. With reference to the above mentioned subject, the undersigned is to inform him. It is clear from his report that Mahiuddin was neither engaged against any sanctioned post in Shahpur 2 Gram Panchayat and under Golpoke 2 Panchayat Samiti, nor was issued any sanction approval from the block development officer Golpoke 2 block towards such appointment, and thus the petitioner does not fulfill the criteria of the above mentioned memoranda of Finance Department to receive such benefit. Therefore, petitioner Mahiuddin is not entitled to get any privilege enshrined in the memorandum number such and such. Once they say one thing, my lord, it is a settled proposition of law. State cannot vitiate its stand, changes its stand at its discretion. Once you have decided, you cannot change the merit of the case in this way. Now, my lord, I would trouble your lordship not for much. Kindly, your lordship takes the next page. Kindly see how with the change of guard, everything changes. My lord, kindly take the next page. My name is there, just like the previous tabulation. My lord, kindly see. Serial number 8. Whether engaged against sanction post, now it becomes no. Once you submit yes, then you say no. This is not the government authorities must act. Now, my lord,
Okay, got you. Yes.
My lord, my answer is lies in the paragraph 4 of my reply. My lord, in page 2, in compliance with the Honorable High Court's order dated 8 December 2020, a hearing was arranged on 8 March 2021 in the Department of Panchayat and Rural Development. The Special Secretary of this department heard the petitioner since the report from the District Authority, Uttar Dinajpur, over the claim of the petitioner as unavoidable during time of hearing. The Special Secretary of this department relied on the documents submitted by the petitioner. There is no scope to get them verified by the District Authority from their office record. The same was reflected in the order dated 9 March 2021 issued by the Special Secretary of this department, whereby it was stated in the observation that apparently the claim of the petitioner seemed justified against the documents submitted by him, which is a conjecture. It was also stated that if the EO or AEO of the concerned Jela Parishad endorses the above stated matter in the prescribed pro forma annexed to the Finance Department's memo number 9008 FP dated 16th September 2011, his prayer can be placed before the competent authority as per the provision of the above stated memo in this regard. Hence, it is a very clear that the entire final decision in the matter is dependent upon the issue of submission of pro forma report by the EO or AEO of the district Uttar Dinajpur. Since no report in the prescribed pro forma was received from the district authority Uttar Dinajpur at the time, no final conclusion over his claim could be drawn. The additional district magistrate and additional district magistrate Uttar Dinajpur Jela Parishad by memo number 403 Panchayat dated 30th September 2021 submitted report in the prescribed pro forma in that manner. Based on the report submitted by the additional district magistrate and additional executive officer Uttar Dinajpur Jela Parishad, the special secretary of Panchayat and Rural Development Department height memo number 5074 and such dated 7th October 2021 duly informed that the petitioner is not entitled to get any privilege enshrined in the memorandum 9008 FP dated 16 September 2011, read with the memorandum of subsequent memorandum, as the petitioner does not fulfill the terms and condition of those memorandum. Now, your lordship kindly come to the annexure R1.
Have you annexed all these memorandum?
Is there
This memorandum of
Yes.
which department?
These are all annex, I believe. Yeah. Annex,
Finance department.
All memos are not annexed.
The state ought to have come with the memo.
You want to show which?
I'll kindly come to page.
দেখাচ্ছেন আমাদের কাছে সার্ভিস হয়েছে, কপি
হ্যাঁ।
সার্ভিস হয়েছে। এটা কি? এটা কি রিপোর্ট? এফিডেভিট
রিপ্লাই তো দিয়েছি।
কোথায় রিপ্লাইটা কোথায়? এফিডেভিট রিপ্লাইটা কোথায়? নেই তো, আমাদের কাছে দেওয়া হয়েছে এফিডেভিট রিপ্লাই?
দেওয়া হয়েছে।
Reply to the report in respect of report.
অপোজিশনটা রয়েছে, রিপোর্ট কোথায়? Possibly we have not received it, subject to correction by my learned friend. না, আমরা পাইনি বোধহয়। দেখুন তো একবার, হতে পারে দিয়েছেন না
দেওয়া হয়তো দিয়েছি।
না, হতেও পারে দিয়েছেন আমাদের।
Okay, I'm keeping under the heading for order you.
If
Get a copy, what can be done? Get it copy.
I think these documents have already.
Don't want to rely upon any judgment.
My lord, these documents have already been annexed with the previous opposition. I have already annexed these documents.
Okay, do you want to rely upon any judgment?
Judgments are there, my lord, on this point, but this is a factual consideration. I can go for the judgments, but
have you brought Jaggo, Sripal, Vinod, Kumar?
I'm not equipped today, my lord, with those judgments. I'm not equipped today with those judgments, but Vikramnath, yes, regularization judgment on that.
2020, Justice Vikramnath can also bring the
yes,
Umadevi
but the
2006.
regularization is concerned. There are
judgments are subsequent.
You cannot use
to bring the Jaggo judgment.
You
Jaggo,
cannot.
Sripal.
Yes. One has been given in the December 2024, another has been given to April 2025.
Yes, Sripal and Vinod. And before that, Jaggo. Justice
Jaggo is, my lord.
Justice Vikramnath has clarified that the Umadevi judgment is only to prevent the illegal appointment.
Right.
But the same shall not give the passport.
Yes.
Passport and weapon to them and tool to them to exploit the
service of this. Yes, my lord.
The casual worker and such for indefinite period.
Right.
Okay, bring that judgment. As a hard the learned advocate appearing for
my lord, your lordship is fixing, my lord, kindly fixes a date, my lord. Kindly fixes a date of this charge.
Under the heading for order, you will make further submission.
Yes. That's judgment.
Okay, I have got you.
Yes.
I have got the hints. and hence for order. Okay.
My lord, your lordship fixing any date? Any date your
Uh,
lordship is fixing?
Any date, my officer তার আগে পাঠিয়ে দিবেন এগুলো করে পাঠিয়ে